Be seated. Here on the record in CR 2015-001671-001, 003, and 004, State of Arizona versus Gerald Bowman, Marcus Morris, and Markeith Morris. For the record, we are in the presence of the jury. All counsel and all defendants are present. Detective Santos is back on the stand and still under oath. Mr. Eckstein, your continued cross-examination when you're ready.
Thank you, Judge. Good morning, Detective. When we finished up yesterday, I was asking you about your request to Mr. Hood for his phone to take certain records off of there. You recall that?
Yes.
I think you would explain this on direct, that what you wanted off the phone were text messages between Eric Hood and Thomasine Morris on the 24th and 25th of January. Is that right?
Yes.
And that's all you were expecting to get off the phone, right?
Yes.
And that's all you discussed with Mr. Hood, that you wanted those specific records, correct?
Yes.
Mr. Hood told you in the context of your investigation of this case that he had no financial motivation, right, with respect to this case?
Well, he never specifically said I have no financial interest. It never was discussed.
Well, he told you explicitly, Detective, that this wasn't about money for him, right?
Yes.
And when you and I spoke about that topic in our interview some weeks ago, you told me that if you learned he'd had a financial motive, you would have documented that because it would have been important to the case, right?
Yes, I would have documented that.
I think what you told me is that, in part, you thought that might be a conflict of interest.
Yes.
You said that it's almost like trying to exploit someone who committed a crime against you, right?
I don't remember saying that, but maybe, did you ask me that and I responded?
No. If you don't recall one way or another making that statement?
No, I don't.
And then you said if a person is assaulted and they're trying to work up some kind of situation, or they're corresponding with other people, that, hey, you know what, I'm going to make a lot of money off this right here. I just got to keep holding on, and I got to do this, and the payoff's going to come eventually, that it's just not appropriate. That's what you told me.
I would object as improper impeachment. I'm unclear as to who he's speaking as to Mr. Hood's statements. Is that correct?
Could you restate your question?
Sure. I'm speaking generally with respect to a case. So to number one, Mr. Hood had told the detective that he had no financial motive or interest in this case.
Could you just restate the specific question you want him to answer?
That in our conversation, following up on your telling me that you thought it would be a conflict of interest, and I asked you in what way, and then you told me that, what I had just described. You recall that?
Somewhat, yes. I mean, I don't remember that verbatim, but I do recall making a statement.
Right, and then I asked you if you apply it to this situation when you have two defendants who are professional athletes, whether you agreed with me when I suggested that an investigator would be concerned that a victim would be incentivized by the prospect of money to include those individuals who have money in the claims they bring against them. Do you remember that?
Just right after you said the victim
would be incentivized by the prospect of collecting money to include claims against the people who are professional athletes.
Yes, that would show a certain motivation, which would be a concern to me.
In the course of your investigation, that you never learned anything to suggest that Mr. Hood had a financial motive, right?
That's correct.
It wasn't until trial that you saw any evidence of that, correct?
Well, I don't know if it was specifically Mr. Hood. I recall seeing evidence that were text messages, but I thought those were the witnesses' text messages to some other person and not Mr. Hood.
You don't recall Mr. Hood's text messages to individuals in the weeks following the events where he was talking about asserting a $10 million claim and not settling for less than $7 million?
Okay, yes, I do recall that.
So you interviewed Mr. Hood just after midnight, so on January 25th of 2015, right? That's when you first interviewed him.
Oh, yes.
This was after he had been discharged from the hospital?
Well, he was still in the hospital. He was still in the emergency room. So the exact time when he was discharged, I believe it was after that interview.
Do you recall when he was discharged then?
No, I don't.
He was discharged just before, just after your interview?
I would say sometime after my interview. I just don't know the amount of time, if it was 30 minutes or an hour.
In that initial interview, did Mr. Hood seem in some way impaired or limited in his ability to describe for you what had happened to him earlier with respect to the assault?
Well, he didn't seem impaired, but I mean, it was obvious to me that he was in pain.
Nothing that would have affected, from your perspective, his ability to recall those events, right?
Correct.
Or provide his best description, his most accurate accounting of what had happened to him, right?
Correct.
Obviously, you would have documented that had you observed that, correct?
Yes.
After that interview, you took Mr. Hood to the Arch, didn't you?
I don't recall taking him. I really don't. Actually, when I went back to the Arch facility, I was doing what I call a walkthrough of the scene. Take a look at it to see if I could find any evidence, but I don't remember anyone being in my vehicle and going back to the scene.
Okay, so obviously you heard Ms. Sherrod testify that you had taken Mr. Hood back there and she had followed you in her car after he got out of the hospital.
I do recall there was some conversation about her following us there because they needed to retrieve a vehicle, but I really don't remember anyone being in my vehicle and me transporting them back to the scene.
Do you remember Mr. Hood being at the scene when you got back to the Arch?
Very remotely. My main objective was to go out there and see if I could basically just get an idea of what the scene looked like.
Do you know if Mr. Hood retrieved his vehicle upon his release from the hospital?
I know that there was talk about that when we were at the hospital, but as far as any vehicle actually being removed from the parking lot, I don't know if it was her vehicle or if it was his.
All right. In your first interview of Eric Hood, he told you that originally he was going to go home after the assault, right?
Yes.
But before going home, he got a call from Alonzo Hickerson, right?
Yes.
And according to Mr. Hood, Mr. Hickerson told him that he had spoken with somebody we now know is Jacob Miller, and a number of players, all of whom they would say they saw both Morrises physically assaulting him, right?
Yes.
Mr. Hood didn't tell you that Mr. Hickerson had said something about any of the other three assailants, just the Morrises, right?
Correct.
And Mr. Hood also told you that Mr. Hickerson was his mentor, correct?
Yes.
That he's known him for more than 20 years.
I don't remember how many years, but he did say that he was his mentor.
And as an investigator, this is critical evidence to you. Independent witnesses, third parties who are going to attest to the details of a physical assault. Who assaulted a person, where it happened, that information is critically important to you, right?
Yes, it is.
The next morning, you called Alonzo Hickerson, didn't you?
Yes, I did.
And in that conversation, he identified three witnesses who he told you originally saw the entire incident, didn't he?
Yes.
He told you Jacob Miller, Mustafa Halal, and Nives or Knives Gilbert.
Yes.
You know how to pronounce her name?
I believe it's Nives.
Nives. In that call, Mr. Hickerson didn't say anything about the players having seen the assault, right?
Correct.
And Mr. Hickerson told you that he had spoken with both Jacob Miller and Mustafa Halal the night before, the night of the assault.
I believe so, yes.
In fact, he said he'd spoken with Jacob Miller for hours last night.
Judge, I would object hearsay at this point.
Sustained.
Do you know who Knives Gilbert is?
Yes, I do.
Who is she?
She is a lady who was at the Arch facility that evening when the incident occurred. And she indicated that she was walking outside of the facility with the victim.
She told you that she was walking out with Mr. Hood, and what did she say she observed when she got outside the gym doors?
I would object hearsay.
Sustained.
If we could approach her.
Yes. Come on up.
From your interview of Ms. Gilbert, did you learn anything that caused you to believe that something had taken place in between the gym doors and the parking lot?
There was very minimal information, but I do recall that she indicates that she sees someone running, I believe, but it was very minimal information.
Running where?
Towards the field.
Not falling near the gym doors?
Well, she indicated that she was coming out of the gym doors with the victim and that all of a sudden there was some type of an altercation, but she was not able to describe in detail what had occurred.
You later interviewed coaches Miller and Halal, right?
Yes.
At least 2 times each?
Yeah, at least, yes.
You've heard their testimony here in this court?
Yes.
And as they described, neither of them saw Marcus Morris or Markeith Morris hit or kick Eric Hood, right?
That's correct.
Rather, you heard Mr. Halal describe that when he came out of the gymnasium doors, he saw Marcus and Markeith Morris. If I could.
Yes.
19.
Can you hit the button?
I think his testimony was that when he came out of the gym doors, looked in the parking lot, didn't see anything, right?
Correct.
Then looked into the field, in this area here, above the word field, and saw Marcus and Markeith Morris, correct?
Yes.
And that Marcus and Markeith Morris proceeded to run down this driveway and, got close to where they saw Mr. Hood, who was laying on the ground somewhere near the gate on 219. Is that right?
Well, I believe you're talking about
Mr. Halal.
Halal?
Yes.
Okay. Mr. Halal indicated that as him and Mr. Miller were running, when they eventually got closer towards the end of the field or the entry exit, that he saw one of the twins that was, I believe he said, about 10 to 15 feet away from the victim while he was on the ground.
Right. Yeah. So he runs out of the gym door. He sees, I believe he identified that person as Marcus Morris, correct?
Close to the victim at the end of the drive? Yes.
That's what Mr. Halal's testimony was?
Yes.
Right. That he sees, Marcus Morris, they're running down the driveway, and then when they get close to the gate and he sees Mr. Hood, he sees the person he thinks is Marcus Morris about as far away from where Mr. Hood is on the ground from where I'm standing to the courtroom deputy table, right?
Yes.
And Mr. Miller's testimony was similar, except he did not see Markeith Morris, or Marcus Morris, excuse me, or the person he believes is Marcus Morris at all until he got down to the end of the property, right?
Well, he indicated that once they got out the doors and their attention was drawn to the drive, that he saw one of the twins by his vehicle and then asked him what was going on as they continued to walk down the drive.
Mr. Hickerson, did he give you any information about where other witnesses might have been during the altercation?
Well, he indicated that there were players that were leaving the game and that they were getting into their vehicles, but he really did not give any specific information that would give me a solid witness.
Right, so did he say where the players and coaches who were leaving the game, where they might have been on the property?
I would object to hearsay.
Sustained.
Mr. Hickerson told you that he thought what happened in this incident was wrong, right?
I'm sorry.
That he thought what happened was wrong,
I would object to hearsay.
not for the truth of the matter, sir.
Just overruled.
Yes, I remember him having that opinion.
And that if the Morrises got to pay, they got to pay, right?
If can you say?
Words to you, that I believe what happened was wrong, and if the Morrises got to pay, they got to pay.
I remember something similar to that.
Of course, you didn't learn until last week that Mr. Hickerson was attempting to suborn perjury in this matter, right?
Objection calls for a legal conclusion from the witness.
Sustained. Rephrase, please.
That Mr. Hickerson had offered at least 2 witnesses some financial payment in exchange for testimony implicating Marcus Morris and Markeith Morris.
I would object as to facts not in evidence. I believe one of those 2 witnesses indicated was his interpretation that referenced financial motivation.
Sustained. Could you rephrase?
That with respect to 2 witnesses, for both of them, Mr. Hickerson had told them or suggested that, rather asked them to provide testimony implicating Marcus Morris and Markeith Morris, right?
I recall that, hearing that.
That he wanted them to say that they had seen Marcus and Markeith physically assaulting Eric Hood, correct?
Judge, I would object. He's offering prior consistent statements.
Sustained.
And that with respect to at least one of those individuals, there would be a financial payment to that individual were he to do that, correct?
Same objection from the state judge.
Overruled. You may answer that question.
I recall hearing that information.
You weren't part of the state's efforts to locate Mr. Hickerson for this trial, were you?
I wasn't what?
Part of the state's efforts to locate Mr. Hickerson to bring him here for this trial.
No.
You know some effort was made in that regard?
No, I wasn't aware of that.
You weren't?
No.
You weren't aware that the state attempted to reach Mr. Hickerson, but he somehow didn't respond to any of their efforts?
I really don't recall anyone telling me we're looking for Mr. Hickerson.
You had communications over the course of your investigation with, I think, three different attorneys who told you they were representing Eric Hood. Is that right?
Yes.
Christopher Williams, Eric Bowman, and David Rubin.
The first one, I don't remember. Williams?
Kit or Christopher Williams.
That name doesn't sound familiar to me, but David Rubin, and I spoke to David Rubin, but Bowman, I don't know if I ever had any conversations with him.
And you told me when we spoke some weeks ago, it was unusual in your experience to have the amount of contact with a victim's lawyer such as you did in this investigation.
For me to have contact?
Yes. The amount of contact that you did in this investigation.
It's, I believe it's unusual.
And you told me you had a number of conversations with Mr. Rubin in particular, is that right?
Yes.
And you had asked him really for any information that would be helpful for the investigation, right?
That I asked him?
Yes. If he could identify witnesses or provide medical records or provide you with any information that would help further the investigation, correct?
I already had most of the information that I needed. So I do recall at one point in time, because he attempted to contact me several times, that I did make a statement. If you have any information or evidence that would lead me to solve this case, then please provide that to me. But I believe that was only one time.
And he never provided you with anything, right?
No.
Mr. Hood testified on redirect examination that Marcus Morris had kicked him in the nose, breaking it. You recall that testimony?
I remember him indicating that Marcus assaulted him, but it's specifically where he may have hit or kicked him, I don't remember.
I'm not asking you, I will in a moment ask about the interviews you performed. I'm asking about his in-court testimony. Do you recall him testifying that on redirect that Marcus Morris had kicked him in the nose?
I don't remember it.
You had interviewed Mr. Hood 4 times substantively for this case, right?
Yes.
He was interviewed once by Officer Berglund, correct?
Yes.
And in one of those interviews, you had asked Mr. Hood specifically where Marcus Morris had kicked him, correct?
Yes.
You asked him, well, do you remember what his response was to that question?
Just vaguely, I remember him indicating that he was kicked all over his body, but as far as me remembering specifically where he said he was kicked at, unfortunately, I just don't remember.
Or if I could approach the witness.
You may.
Detective, I've handed you what's marked as Exhibit 180 for identification purposes, and I've turned it to the portion of that exhibit that contains a transcript from your January 26th interview of Mr. Hood. You want to take a moment to review that, please?
Yes, I recall this.
Okay, what do you recall?
I recall that when I asked him where Marcus had kicked him, he said that he had kicked him in the head, and more specifically that it was on the left side of his head by his ear.
Right. So left side of head, not just by the ear, but above the ear, correct?
Correct.
Okay. He didn't tell you that Marcus had kicked him anywhere else, correct?
No, he did not.
He didn't tell you that Marcus had kicked him in the nose, right?
Asked and answered objection, Judge.
Overruled. You may answer.
That's correct.
Had he said so outside of one of your recorded interviews, I assume you would have noted that in your extensive police report, right?
Yes.
It's a critically important detail, isn't it?
Yes, it is.
Before you interviewed Mr. Hood at the hospital, as described on direct examination, you had been provided a basic briefing that gave you some information as to where this incident took place, the individuals that they thought were involved, and then following that, you interviewed Mr. Hood, and he described to you that how many individuals he believed assaulted him.
I believe he indicated that there were 5 subjects that assaulted him.
And did he indicate in that first interview that he thought all 5 had physically hit and kicked him?
Yes.
Was he vague about that?
No?
He was explicit, wasn't he?
Well, that initial interview, there was not a lot of detailed information at the hospital. But I do remember him indicating that he said that he was assaulted by at least 5 people.
Well, you asked him who was hitting, punching, and stomping you, and he said all of them, every single ass one. You asked if he was sure, and he said, I'm 100% sure. You recall that?
Yes.
Then another point in the interview, you asked if he could actually tell who was assaulting him, and he responded, everybody that came with them. You recall that?
Yes.
You asked him, did you actually see the twins confronting you? And he said, yes, they was kicking me. You recall that?
Yes.
Then you asked him pointedly, and that you know with certainty that the two brothers were kicking you while Julius was holding you down. And he responded to that, all of those guys were kicking me, no question, no doubt. You recall that?
Yes, I do.
You interviewed him next on January 26th in the middle of the afternoon. You obviously heard Mr. Hood's description of that interview on his direct testimony, but this is the one where you provide him with some maps that he draws on, and he, in the middle of it, leaves the interview for a telephone conversation with his attorney. You recall this interview?
Yes, but I believe that was the third interview that I had with him. One at the hospital, and then a subsequent one on the 26th, I think, and then I think one on the 31st. But I think the third one was the one that you're describing.
Yeah, I'll attest to you, it's the January 26th interview. You have the transcript in front of you. If you'd like to refer to it to refresh your recollection, if you want to take a minute to do that, we can certainly do that.
Well, I do recall that interview.
And you recall in that interview, he had received a number of phone calls, probably 5 phone calls.
Pretty close to that, yes.
And early on, he picked up the phone, he identified the person he was speaking with as his attorney. You recall that?
Yes.
And after a very brief exchange, he then went back to the interview, correct?
Yes.
And as I talked about before, you went through some maps. Obviously, we've published 225. This is from Ms. Sherrod's interview, but this is the basic map that was presented to Mr. Hood for that interview. You recall that?
Yes, I do.
Okay. And he's drawing out where he had run from and where he had run to, correct?
Yes.
And in the context of that, you recall asking him the number of people who had assaulted him.
Yes.
And what was his response?
He indicated that all 5 of the subjects had assaulted him.
In fact, he said he was sure that all 5 of the suspects had assaulted him, right?
Yes, he did.
And then at some point, I think he had told you that he was balled up, protecting himself in this assault, right?
Yes.
And so you asked how he could have seen all 5 people if he's balled up in an assault. You recall that?
Yes.
What was his response?
I believe he indicated that he had his hands to the side of his head, so he was still able to see.
He said he was sure that he saw all 5 guys assaulting him, right?
Yes, he did.
And you asked him if he knew who those people were, correct?
Yes.
And what did he tell you in response?
He said that he knew who 3 of the subjects were.
Who did he say were the 3 people he knew were physically assaulting him?
He said that the twin brothers, Mark Heath and Marcus Morris, were assaulting him, and that also Julius Kane was assaulting him, and 2 other people, but he didn't know who they were.
So then at some point, Mr. Hood steps out of the room for about 12 minutes or so. Recall that?
Yes.
And before that, you had gone through with Mr. Hood what he believed each of the 5 individuals involved in the assault had done with them. You recall that?
Yes.
And you had not yet gotten to Markeith Morris, correct?
I believe so.
So he leaves the room for 12 minutes. He comes back, and the first thing you ask him is actually, what did Markeith Morris do, right?
I believe so.
What did he tell you?
Well, he said that he was not 100% certain that Markeith had assaulted him at the end of the drive.
That's what you recall?
Yes.
Do you recall what he said he had observed?
Did say that he recalled Marcus assaulting him, and that Julius Kane was holding him down at the same time.
How about as to Markeith Morris? Do you recall what he told you specifically?
After the phone call,
Correct.
he just said that he was not 100% certain that he had assaulted him. That he could not say that with certainty if Markeith assaulted him.
Detective, if you want to, well, I'll just ask you. What he told you was that Markeith was back by his vehicle, from what he could remember, right?
I believe so.
He said he knew Markeith was in the vicinity, but he can't say that he actually remembered him stomping him, right?
Yes.
And then you asked some more specific questions. You asked him how, if Markeith was by his vehicle, he could have been in the vicinity. You recall that?
He could have been what?
How, if Markeith was by his vehicle, he could have also been in the vicinity.
Correct.
Because, and I assume what you were thinking is that, that if the vehicle is in the parking lot and Mr. Hood is being assaulted down by the gate, how could Markeith Morris be in those two places at the same time, right?
That's correct.
But how far apart do you think, let's just take the end of the parking lot that's the closest to where the gate is. What distance do you think that is?
That's quite a distance there. I would say an easy 60 to 80 yards, maybe.
I told you it was 100 yards. Would that sound off to you?
No.
So, perfectly reasonable question, given his statement that he was by his vehicle, and Mr. Hood ran by him. You asked if the vehicle was potentially on Coulter Street, right?
Yes.
You recall Mr. Hood's response to that?
No, I don't.
But what he told you was it was not on Coulter Street, that it was back in the first line, right?
Yes.
And you asked him how could he see him, how could he have seen Markeith if he's by his vehicle and Mr. Hood is way over here by the street. You recall that?
Yes.
But he told you we saw him when he ran past, didn't he? Yes. And you asked if Markeith had stayed by his vehicle or he'd come all the way down to the street. You recall that?
Yes.
And he said he came, he didn't come into the mix, he didn't come in there, he was more so on the back end.
Yes.
And you asked him, specifically what he meant by the back end, correct?
Yes.
And I think there was some, as Mr. Bellinger went through with Mr. Hood on his cross-examination, at that point, you all were referring to one of the maps that you and Mr. Hood were looking at that day.
Yes.
And in response to what someplace he identified on the map, do you recall what you said to him?
No, I don't.
You told him that's quite a ways. Do you recall that?
I think so, yes.
He agreed that it's quite a distance, right?
Yes.
So when I interviewed you about this several weeks ago, you agreed this was kind of puzzling, right?
Yes.
Well, it's more than a little bit puzzling, wouldn't you agree?
Yes, I would agree.
Have you had another case where you had a victim tell you 9 times they saw a specific person physically assaulting them and then suddenly not remember that person physically assaulting them?
It's happened, it's happened before, but not very often.
You've had another case where, well, let me put it more specifically, where someone told you 9 times they saw one particular individual assaulting them, including 2 times in an interview you're having with them. They get a phone call from their lawyer, they're out of the room for 12 minutes, they come back in, and now they don't remember that person who 9 times they said physically assaulted them. They don't remember seeing that for sure.
I've never had another case exactly like that.
Right, and obviously you and I weren't part of whatever conversation Mr. Hood had with his attorney, correct?
That's correct.
We're not entitled to know the details of that conversation, correct?
Yes.
But you agree that one thing that could have happened in that conversation is that Mr. Hood had been told what Jacob Miller was going to say, right?
Objection calls for speculation.
Sustained.
Well, it would make sense, wouldn't it, that if Mr. Hood learned in that phone call that there was going to be some evidence exonerating or exculpating Markeith Morris, he would adjust his testimony to account for that, right?
I would object calls for a legal conclusion and speculation.
I'm going to sustain it on relevance.
So in our interview, Detective, we talked about these 2 totally incompatible sets of statements. What Mr. Hood said regarding Markeith before the phone call and what he said after the phone call. You recall that?
Yes.
You agreed these statements just can't be reconciled with each other, correct?
Objection, relevance.
Overruled. You may answer as it goes to your investigation.
That they can't be what now?
Reconciled with each other.
I'm really not sure what to think. There are several things that were going on in my mind, but I just don't understand why.
Counsel, can you approach for a second?
Sure. Detective, you didn't, after this interview, you didn't ask Mr. Hood any more about these change statements as to Markeith Morris, right?
No, I didn't.
Mr. Fisher had asked you on direct examination about some confrontation calls in this case. You recall that?
Yes.
And I think it was described in your testimony that you had wanted Mr. Hood to engage in confrontation calls with Alonzo Hickerson and Thomasine Morris. Is that right?
Well, the initial intent was to have a call with Thomasine only.
I think you described this in your direct testimony that you were present with Mr. Hood on February 3rd of 2015 when you gave him the equipment and walked through with him, how to use that equipment with respect to a confrontation call, right?
Well, I didn't give him any equipment. I was there and I wanted him to initiate a call to Thomasine.
So an effort was made to call Ms. Morris, but that didn't connect that night, correct?
That's correct.
I think you said this, that he did connect on a call with Mr. Hickerson that night, and you were present for that, correct?
Yes, what happened was, while we were there and discussing the confrontation calls, he received a call, and it was from Alonzo Hickerson. And he wasn't sure what to do, and I said, go ahead and answer the phone, and let's go ahead and record this conversation.
And what happened in that conversation?
There was very minimal information that was provided, and actually the call actually terminated. I don't know if it was intentional or not. And then he attempted to call him back, but there was no answer.
Do you recall any conversation taking place about Jacob Miller?
Yes.
And what was that conversation?
That I don't recall.
I wonder if I could approach the witness.
You may.
Detective, on Exhibit 180, I've flipped to the portion that includes a transcript of this call. I want to go ahead and review that and see if that refreshes your recollection. That page.
Okay.
Page 3 of the transcript. So what do you recall about the conversation regarding Mr. Miller?
There was some conversation about that Mr. Miller was most likely upset because he had received a call from an attorney, and it had something to do with whether or not he had insurance for the game that he had going on at the Arch facility that weekend or that evening.
Anything else that you recall?
That he probably wouldn't say anything. And I recall Hickerson saying something about it had something to do with, well, he called it the suits. He was talking about the attorneys involved in the incident.
So what Mr. Hickerson said to Mr. Hood was that Jacob Miller probably wasn't going to play ball anyway, right?
That's correct.
Sometimes he can use that as an excuse for not to play ball, correct?
Yes.
That was his useful excuse not to play, correct?
Yes.
So you didn't know then that Mr. Hickerson had tried to convince Mr. Miller to provide false testimony in this case, correct?
I was not aware of that, no.
So let's talk about that in the context of what we now know. If I could approach one.
Me.
Publish 184. So as you described before, Detective, Mr. Hood told you that just after the incident, he was going to go home originally, correct?
He was going to go over what?
He was going to go home.
Yes.
Then he received a phone call at 7:29 p.m. from Alonzo Hickerson, right?
Yes.
And we've discussed what happened in that call before. So in response to that, Mr. Hood goes to the hospital and he calls the police, correct?
Yes.
And Mr. Hickerson and Mr. Hood, you can see in Exhibit 184, attempt to call each other back and forth 10 more times this night.
I see that now.
And they actually speak, I think, three times. Or at least the calls connect 3 times.
But yes.
And you heard in Mr. Hood's testimony that Mr. Hickerson helped arrange for him to begin discussions with a lawyer that night, right?
Yes.
That person is Eric Bowman, correct?
Yes.
And that in that effort, Mr. Hickerson forwarded to Mr. Hood a text message explaining that the individual who had sent that message to Mr. Hickerson would have a $1 million demand letter in the Morris's attorney's hands Monday morning, right?
Are you asking me if I saw that in court?
Yes, that's what I'm asking you.
Yes, I remember seeing that.
Right. No, I know you did not have the opportunity to review the voluminous text messages and other information off the phone. And so after that, all that happens, you have your first interview of Mr. Hood, correct?
Yes.
I'm sorry, yeah. Your Honor, if I could approach the witness.
Yes?
So Detective, I've handed you what is marked as Exhibit 184. I want to ask you a few questions based on that, so you have the opportunity to look at it. Mr. Hood speaks with Mr. Hickerson, I believe 4 times between your initial interview of him, so that's just after midnight on January 25th, and your January 26th interview, which is about 4 o'clock in the afternoon.
Yes, I see that.
And you heard Mr. Hood explain in his testimony that he had hired Mr. Bowman to represent him in the context of this case, right?
Yes,
He had done so sometime around your initial interview, before, after. I'm not sure exactly when. Does that sound right?
yes,
And Mr. Hood had a number of telephone conversations with Mr. Bowman over the same period of time. So again, between your initial interview and your second interview with him, I think there are, between Mr. Bowman and Kit Williams, there are eight such phone calls.
yes.
Did you learn at any point whether Eric Bowman or Christopher Williams were in fact licensed to practice law in the state of Arizona?
Relevance.
I didn't know who either one of these two guys were, whether they were attorneys or not, and it was really irrelevant to me as far as my criminal investigation.
You've never learned anything in that regard?
No, nothing. I don't recall anything that would confirm, like a letterhead or a business card or an email.
Okay.
Nothing.
So then let's flash forward. We have the January 26th interview, and as we've discussed already, this change in testimony from Mr. Hood as to Markeith Morris, right?
Yes.
And you learn last week that there was some effort on the part of Alonzo Hickerson to have Markeith Morris to have Jacob Miller falsely implicate Markeith Morris, right?
Well, I recall learning information that sounds very similar to that in here in court.
And you heard him testify to that effect?
Yes,
You heard him testify that the same was asked of him with respect to Marcus Morris, correct?
yes,
And that Alonzo Hickerson had made the same offers to Mustafa Halal, correct?
yes, I recall hearing that.
And they, both Mr. Halal and Mr. Miller, indicated that these conversations they had with Mr. Hickerson were around this time frame, in the days following the assault, correct?
Yes,
Needless to say, if you had learned at the time when you first spoke with Mr. when you first spoke with Mr. Miller and Mr. Halal, you would have investigated these allegations, correct?
yes, I would.
You would have ferreted out whether there were efforts to have other witnesses testify falsely, correct?
Yes, I would.
And you would have investigated to see whether there was any connection between these allegations and Eric Hood, correct?
Yes, I would.
But because you just learned of these things last week, right?
Yes.
You've had no chance to do that.
No,
Mr. Hood testified that he had, in addition to the one call with Mr. Hickerson, a separate confrontation call with Thomasine Morris. You recall that?
yes,
And there was some question about who actually recorded that telephone conversation. You recall Mr. Hood's testimony there?
yes, I do.
I think he believed it was the police department that had recorded that conversation. You recall him saying that?
Yes, I recall that.
Did you record this conversation?
No, I did not.
Did anyone else in the police department, to your knowledge, record this conversation?
No,
Who provided you with the recording of that?
that was Mr. Hood.
You had earlier, 8 days earlier, explained to him how to record a call, correct?
Well, he asked me because we were having a hard time making a connection. And I had advised him that if someone were able to provide me information, that I would be more than happy to go ahead and take that as evidence. But it's not common practice for me to tell someone, can you go ahead and do a confrontation call? If they happen to call someone and there's information that's relevant to the case, well then I would certainly accept that as evidence.
Do you recall the length of the recorded call that Mr. Hood provided to you?
Yes.
How long was that?
I believe it was about 17 minutes.
You know how long the actual call was between Mr. Hood and Thomasine Morris?
I learned later on from your office that it was about 30 minutes.
On the call log that you have in front of you, if you want to look to call 231, so we're not guessing about this, or you're relying on what I've told you.
Number 231?
Yeah, the call numbers should each be in the left-hand column.
Yes, I see that. 30,
But what is the length of that call?
30 minutes and 42 seconds.
Did Mr. Hood ever tell you what happened with the missing 13 minutes of recording?
There never was any discussion about that.
You have no idea why he gave you a partial recording?
No, I don't.
Or what happened in the part of the call that you never got?
That's correct. I don't know anything about that.
You had some discussion with Eric Hood about Thomasine Morris prior to this confrontation call, correct?
Yes.
He told you that he was speaking with Thomasine Morris all the time, reference to sort of January of 2015, right?
Yes.
And that he believed she had no knowledge of anything related to this assault, correct?
Correct.
You heard Ms. Sherrod's testimony, correct?
Yes, I do.
Your Honor, 223.
Yes.
And what I'm showing on the overhead now is the third page of Exhibit 223, where Ms. Sherrod identified in her interview with you, January 26th interview, where she saw, she says, 5 individuals physically assaulting Eric Hood, right?
Yes.
She said in her interview she saw this assault taking place between the picnic tables and the parking lot, right?
Yes.
Do you know how many witnesses were interviewed in this case?
Not exactly, but I would say probably there are 30 to 40 listed witnesses.
And a number of those witnesses are individuals who were players or coaches or parents associated with the basketball teams that were involved in this tournament at the Arch, correct?
That's correct.
And some of those individuals, I want to say 20 or so, were between the gym doors and the parking lot right after that last game let out, correct?
Yes.
And there is not a single other witness who attests to having seen anything in this area where Ms. Sherrod describes this assault having taken place, right?
Objection, hearsay.
Overruled. May answer.
I don't recall any of those witnesses that were players making any, providing me with any information that was similar.
Right. And Mr. Hood said, and he testified here, that nothing happened to him in this area, correct?
Well, he described as being attacked right out of the doors, and then he started running, and then he described that he was somewhere in the middle of that field, and then eventually the very end where he was assaulted.
He told you in your January 26th interview that nothing happened to him in that field, correct?
That's correct.
That he just kept running through the field, correct?
Yes.
And so he told you that he was assaulted at two places, at the gymnasium door, correct?
Yes.
And at the end of the property, correct?
That's correct.
You asked Mr. Hood what kind of relationship they had, right?
What kind of relationship he had with who?
You asked both of them what kind of relationship they had with each other, Ms. Sherrod and Mr. Hood.
Oh, yes.
Why did you do that?
Well, the main reason why is because they indicated that they were at the tournament together. I really didn't know if they had a relationship, and that would be important to me if they were married or if they were boyfriend and girlfriend. That would have some type of bearing, I believe, as far as I'm not sure really how to explain it, but if there is a relationship with the victim and witness, I would want to be aware of that to guide me in whatever direction I believe that the investigation needs to go.
You'd be concerned about the potential of bias, correct?
Yes.
That if two people were particularly close, they might be inclined to shade or adjust their testimony to help the other person, right?
Yes.
And what did Ms. Sherrod and Mr. Hood tell you about their relationship?
She indicated that there was no relationship, that they were friends only, and she had only known him for a short period of time.
And you never learned anything before this trial to suggest that Ms. Sherrod had not been truthful with you when she said that, right?
That's correct.
One moment, Your Honor.
Yes?
Nothing further, Your Honor.
Detective, you've sat through every day of this trial.
Yes, I have.
And when you first testified, you indicated that you were the case agent for this case.
Yes.
That What that means is that you are the quarterback of the case, right?
Yes.
And that analogy is that every decision that's made in this case is essentially, it's your decision regarding how the investigation will go and in what direction it will take.
Yes.
And your job is not to get a specific result. It's just to investigate what happened, correct?
That's correct.
And you're supposed to interview witnesses in order to find out what happened, correct?
Yes.
And you're supposed to look at documents in order to find out what happened, correct?
Yes.
And you're supposed to, if somebody's story all of a sudden becomes incredible or suspect, you're supposed to circle back and determine why is that story incredible or suspect, aren't you?
Yes.
You're not supposed to have any kind of bias or partiality in favor of the victim in this case, are you?
That's correct.
And likewise, you're not supposed to have any bias or partiality in favor of the defendants, the people that are charged with the crimes.
That's correct.
And as you're sitting here, let me ask you this, and I don't know if anybody's asked you to do this. What have you reviewed for purposes of preparing to be a witness in this trial?
I'm sorry, what was that?
What have you reviewed for purposes of being a witness in this trial? In anticipation of sitting in that chair, what did you look at in order to prepare yourself?
I've reviewed the police report, and I've also looked at some of the evidence that we've seen here, such as the photographs and other documents.
Have you reviewed the interviews that you've taken of Mr. Hood? In other words, there's transcripts of interviews that you conducted with Mr. Hood, one on the evening of January 25th at 12 or 4 a.m. Did you review that transcript of the interview?
No, I did not.
Did you have the opportunity to do so?
Actually, I attempted to. However, I was not able to download the correct player for it.
Would you have been able to ask, for example, Mr. Bailey or Mr. Fisher, hey, I'd like to get a transcript of those interviews that I conducted of the critical witnesses in this case so that I could see the questions and answers that were asked?
I suppose I could have asked him.
So you could have done that,
I could have asked
but
him.
you didn't do that.
No.
Did you review the interviews that you conducted with Ms. Sherrod?
The audio interview?
Or the transcripts, audio or the written transcripts of those interviews?
The only thing that I interviewed relevant to the interviews were the police report that I had authored.
The police report that you authored,
Yes.
that's the only thing that you reviewed
Yes.
in terms of a written document?
Yes.
You've heard the name Alonzo Hickerson come up during the course of this trial, correct?
Yes.
And the reason you've been a police officer for 25 years.
Yes.
You've conducted maybe 19,000 or 20,000 investigations.
Yes.
It is a significant event to you as a police officer when you come across information that an individual, any individual, but in this case somebody like Alonzo Hickerson, is attempting to influence the testimony of a witness. That's a big deal to a police officer, isn't it?
Yes, it is.
In fact, it's a felony, isn't it?
Yes, it is.
So when you heard Jacob Miller, from where you're sitting, say that Alonzo Hickerson had asked him to lie about the Morris brothers' role in this offense, that should have been a significant fact to you, correct?
If I was aware of that, yes.
not suggesting that you were aware of it earlier, but when you heard that on the stand, that was a significant fact to you, wasn't it?
I would have to investigate that further in order to corroborate the allegation.
What would you do in order to investigate it further? You'd probably talk to Alonzo Hickerson, correct?
Well, if I understand you right, you're talking about information that I just learned here in court.
Right.
Okay, so that's an entire incident in and of itself. And my purpose here is to go ahead and testify in court, not to investigate another incident.
I understand that, but you sat here and you listened to two persons who are witnesses in this case testify under oath that the mentor of Eric Hood asked them to lie about what they saw. That was a significant fact to you, wasn't it, Detective Santos?
Yes.
And if Alonzo Hickerson walked in those doors right now, based on what you heard two witnesses say under oath, you would have a legitimate basis to arrest him, wouldn't you?
Objection relevance.
Overruled.
No, in order for me to feel confident in making an arrest, I want to go ahead and obtain as much information as possible to corroborate that information, not just on one or two persons making a statement under oath.
So what you're saying is that the two witnesses that testified here under oath, Jacob Miller and Mustafa Halal, when they raised their hand and they said they were going to tell the truth, and they told us that they had been solicited to lie in this proceeding, that would not be a sufficient basis for you to arrest Mr. Hickerson if he walked into these doors?
Well, I believe you're asking me what type of law enforcement action I would take here in court. And I really can't answer that question unless I had sufficient evidence and information to make sure that I have absolute probable cause to make an arrest. And that's not my objective right now at this point.
I understand that it's not your objective, but what would you do? Would you circle back and try and get a little bit more information to determine whether or not Jacob Miller was telling the truth when he testified to us?
If this was an ongoing investigation, I certainly would entertain that.
The case against the defendants that we're sitting here in trial on right now, that is no longer an ongoing investigation, correct?
That's correct.
But the potential offenses that the witnesses talked to Mr. Hickerson about, that's an independent criminal offense that could be investigated, correct?
Well, I suppose that could. However, in the normal course of my duties, detective, working in the Violent Crimes Bureau, it's very common, it's actually common practice for us to respond to calls for service that patrol officers respond to. So for an incident to be initiated by myself, where I'm testifying in court, that's not our normal course.
So the fact that you have, I don't want to belabor this point too much more, Detective Santos, but you understand that what Alonzo Hickerson did, if Jacob Miller and Mustafa Halal were telling the truth, was a felony inciting, influencing a witness to lie in a case before this superior court. You understand that's a felony?
Yes.
I don't know if Mr. Eckstein asked you this or not. If he did, Mr. Fisher will tell me or he'll object. But if you had that, you indicated, strike that, you indicated that Mr. Hood and Ms. Sherrod gave you their telephones for purposes of you extracting information from it, correct?
Yes.
And that they signed a consent to that effect, correct?
Yes, they did.
And the consent was very limited. It was for a limited amount of information.
That's correct.
But, and as it turns out, as Mr. Fisher described it, the Phoenix police, when they got the phones, extracted a significant amount of information.
Yes.
And so when you say that Mr. Hood and Ms. Sherrod consented to the search, they didn't consent to all of the information that we've seen in terms of text messages that have been on this video screen, did they?
That's correct.
And so we would not have known, for example, that Ms. Sherrod was texting that she was likely to make $20 million because she's a witness. She's going to be a witness in a case against the Morris brothers. We would never have known that.
That's correct.
And we wouldn't have known various text messages from Mr. Hood that if this case is against the Morris brothers, it's a $1 million type case. We would not have known that, would we?
No, we wouldn't have.
You had the opportunity, and I understand that it was a lot of information and it potentially wasn't digestible, or it was a lot of information. It would have been a lot of work. But you had the opportunity to go look at those text messages and see what was the content of them was, didn't you?
Well,
Not that you did, but that you had the opportunity to do so.
well, there's certainly an opportunity. However, I'm not an expert or even I have very, very limited experience with cell phone technology as far as forensics are concerned, and the equipment that the police department utilizes to be able to interpret that.
Understood that you probably couldn't extract the information, but you certainly had the expertise to read the text messages that were extracted from those phones. Didn't you?
If that information was open and provided to me, then yes, I would be able to read it.
You agree that it's a significant concern to somebody like yourself, the impact of money in a case like this influencing a witness's testimony, don't you?
Yes.
And that was, and even though you did not know about Mr. Hickerson's soliciting of the lies prior to this trial, had you known about that back before you filed your police report, you would have investigated that, wouldn't you have?
Yes, I would have.
Because it has the potential for materially compromising the integrity of testimony in a trial like this, doesn't it?
Yes, it does.
And in fact, it raises questions about the very basis of testimony in a case like this, if there's some potential that money is influencing their testimony.
That's correct.
Mr. Approach, everybody, please. We are on the record in CR 2015-001671-001, 003, and 004. State of Arizona versus Gerald Bowman, Marcus Morris, and Markeith Morris. For the record, we are in the presence of the jury. All counsel and all defendants are present. Detective Santos is back on the stand and still under oath. Mr. Ballinger, you may continue when you're ready.
Thank you, Judge. Mr. Detective Santos, you understood that there were two other defendants in this case besides the three people in the courtroom, correct?
Sorry, I didn't hear you.
As the case agent, the person that was in charge of this matter, you understood that there were two other defendants in this matter besides the three people in the courtroom, correct?
Yes.
You understood that that was Julius Kane and Christopher Melendez, correct?
Yes.
You know, you understand that they pled guilty in this case to the charges that were lodged against these defendants, correct?
Yes, I understand that.
You heard Mr. Halal's in-court testimony. You were sitting here as the case agent.
Yes,
And you know Mr. Halal, he was the assistant coach at West Wind Academy.
yes,
Okay, and he described that he saw one person involved in the fight at the end of Coulter Street. You remember that?
yes,
And he described that person as being a little guy, about 5'8" tall.
yes,
Correct, right. And you are aware of the, you know who Christopher Melendez is, correct?
I do.
And you're aware of the fact that he's approximately 5'8" tall? I think you told on direct examination, you said that you interviewed approximately 30 or 40 people in this case.
Yes,
And you had conducted at least, we've gone through this before, 2 interviews with Mr. Hood. There were more than 2 interviews, but there was one on the, right after midnight on January 25th of 2015, correct?
yes,
And then there was another one on January 26th,
yes,
a couple of days later. And on that January 26th interview, Mr. Hood, after having told you at least 8 or 9 times that all 5 defendants were involved in touching him and hitting him in the fight, he changed his story and said that Markeith Morris was somewhere substantially removed from the fight, didn't he?
yes, he did.
And that was after an approximately 13 or 14-minute telephone call with what he described to you as his lawyers.
Yes,
And did you ever ask him to name the people that were on that telephone call?
no,
So you have no idea who was on that telephone call?
no, I don't.
You could have asked him who was on that telephone call, correct?
I could have, yes.
And it could have been Alonzo Hickerson.
It's a possibility,
Because
yes.
he was telling you, when he was relaying that conversation, that not that his lawyer was telling him what to do, but they were telling him what to do. The persons on the telephone call, they were telling him what to do in terms of your interview, correct?
Yes,
You also indicated, and this is, you had spoken to Ms. Sherrod, and she described what she described in terms of right outside the gymnasium, there was a fight and a bunch of people were involved. Do you remember that?
yes, I do.
And you said you interviewed approximately 30 or 40 people in this case, correct?
Well, not me alone. I had 2 other detectives that assisted.
You're the case agent.
Yes,
You're familiar with every interview that was done in this case, correct?
yes,
You reviewed the work that was done by the people that you were directing to investigate this case.
yes,
And you're aware of the fact that there is not a single person that corroborates what Sharika Sherrod said.
I would object hearsay. He's asking about what other witnesses have relayed to him.
Overruled.
yeah, that's correct. There was no corroborating information.
No other witness, the entirety of the investigation, that corroborated what Sharika Sherrod said happened outside of the doors of the Arts Gymnasium, correct?
No other witnesses, that's correct.
And Eric Hood had told you that, notwithstanding what he had said several times before, that Markeith Morris was not involved in the fight, correct?
That's correct.
And he also said to you that at the doors of the gymnasium or up by the Arch building, he got hit in the head, he got punched, correct?
Yes,
And that as soon as that happened, he sprinted approximately 300 yards down to Coulter Street, correct?
that's correct.
And even though you had interviewed 35, 40, 30 witnesses, that none of them supported what Ms. Sherrod had said, and the victim Mr. Hood, who told you that he could tell these two guys apart basically in his sleep, told you that that assault never happened outside of the doors of the Arts Gymnasium. There was no big fight there. You never went back and checked again with Ms. Sherrod regarding what she told you, did you?
Objection, Judge. He's, first of all, he's asking for a legal conclusion in terms of an assault occurring outside of the gym doors.
Just rephrase your question.
Okay.
Sustained.
Ms. Sherrod described some kind of mayhem involving many people outside of the gym doors, didn't she?
Yes, she did.
And Eric Hood described being hit in the head inside of the foyer of the gymnasium, correct?
Yes.
And then he said there was never any fight outside of the doors of the gymnasium, did he? Didn't he?
Objection. I would ask for clarification. He's talking about outside of the gym doors,
Yeah.
just to be more specific with the witness.
Mr. Hood never said, after he was hit in the head and sprinted 300 yards, he said he was never assaulted again until he got down close to the gate at Coulter Street, didn't he?
That's correct.
And you never went back, notwithstanding all of that, you never went back and did any other interview with Ms. Sherrod?
I believe I did. I had approximately 3 interviews with her.
You think you did?
I believe so.
Okay. Do you have,
Have anything?
were
anymore?
the exhibits collected?
Yes.
I'm sorry, it's a Detective Santos interview, the one that you just used. But it was 180. Yeah, it was the one that you did with.
The interviews with Ms. Schrader was 79.
That's what you were showing. Detective Santos, I'm handing you what is marked as was the defense interview ever made an exhibit? You guys know?
I did not mark any of them.
Judge, we have an interview, a defense interview of Detective Santos. And I actually have excerpts of it here. And I can certainly mark it as an exhibit. I don't believe it's marked as an exhibit at the moment.
Are you requesting to refresh his
I'm
recollection?
requesting to refresh his recollection.
If you show it to Mr. Fisher, you can let me know if there's any objection to just using Mr. Ballinger's version. Yes.
Detective Santos, I am showing you the June 22nd, 2017 interview of Detective Santos that was done by, it's the defense interview. Do you remember that interview when Mr. Eckstein and I interviewed you?
Yes.
Okay, and this is page 64 of that interview. Could you read from where it says Bellinger? It's all highlighted in yellow from Bellinger to Santos. You can just read that to yourself.
Okay.
Does that refresh your recollection regarding that no interviews were done of Ms. Sherrod
Yes.
after Mr. Hood changed his story?
Yes, it does.
May I have a second, Judge? I just want to confer with my
Yes.
counsel. I think I might be done. No further questions, Your Honor. Thank you.
Mr. Lackey?
Thank you, Your Honor. Thank you, Your Honor.
Good afternoon, Detective Santos. Now, Detective, Mr. Eckstein talked to you a little bit about the number of witnesses that were in your report. And, well, I guess first off, you did do a report that documented your involvement with this investigation, correct? And counting Mr. Hood, if I were to tell you that going through and just counting the listed witnesses, there were 37 of them, would you agree with me?
Yes, I would.
And of those 37, you showed lineups containing known photographs of Gerald Bowman to 4 of those witnesses, right?
Yes, I did.
Detective, who's Haiti Sanchez?
Haiti Sanchez is a resident that lives in I believe it's either a townhouse or a condominium complex that's right next to the Arch facility, and she lives there. She has the second and first floor of her unit.
And you presented her with a lineup, didn't you?
Yes, I did.
And may I approach the witness, Charlie?
You may.
Let me show you what's been marked as Exhibit 251. Sanchez. Show you what's been marked as Exhibit 251. Do you recognize that?
Yes, I do.
What is that?
That is a copy of the photo lineup that I had shown Heidi Sanchez referenced this in investigation.
That was another question I was going to ask you. Is that pronunciation right? Is it Heidi or Haiti?
I'm pretty sure it's 80,
Okay.
but I'm not certain.
And is that a fair and accurate depiction of what that lineup looked like on the day that you presented it to Ms. Sanchez?
Yes, it is.
Your Honor, I'd like to move for the admission of 251 in evidence.
Any objection?
No objection.
Mr. Eckstein? No objection. Mr. Ballinger? 251 is admitted.
Permission to publish, Your Honor?
Granted. Would you like the lights dimmed, sir?
Yes. Thank you, Your Honor. So, Detective Santos, do you recall whether or not Ms. Sanchez was able to pick Mr. Bowman out of this lineup?
She was not able to.
I'm going to show you what's been marked and admitted as Exhibit 245. Do you recall this specific lineup?
Yes, I do.
And who did you present this, or you presented this lineup to a witness, did you not?
Yes, I did.
Do you remember which witness it was?
That was Mustafa Halal.
And was Mr. Halal able to pick Mr. Bowman's known photograph out of that lineup?
No, he was not.
And I guess the conclusion of that question is, as being a participant in this incident at the Arch on January 24, 2015, not able to identify that known picture of Gerald Bowman as being someone that was present there that evening.
That's correct.
I'm going to show you what's been marked and admitted as exhibit number 216. Are you familiar with this particular exhibit?
Yes, I am.
And what is that?
That is a photographic lineup that I presented to victim Eric Hood.
And in that picture, is there a known photograph of Gerald Bowman?
Yes, there is.
And was Mr. Hood, well, let me ask you this. There's a date on this particular exhibit, and that's January 28th.
That's correct.
So that would have been 4 days after this incident, correct?
Yes.
Would you agree with me that in 19 years of being a detective, that most witnesses, heck, most people, would be able to recall events that were kind of nearer in time than they would be months or years later?
Yes.
And so 4 days after this incident, when presented with this lineup with a known picture of Gerald Bowman, Mr. Hood was not able to identify him as being involved in that incident on January 24th, 2015, correct?
That's correct.
Lastly, I'm going to show you 225, Exhibit 225. Do you recall this particular lineup?
Yes, I do.
And you presented that to someone?
Yes.
Ms. Sherrod?
Yes.
Okay, so, and she was able to, or her testimony or her indication to you was she was able to identify Gerald Bowman from this lineup.
That's correct.
So out of 37 witnesses in this case, out of 4 people that you presented lineups to, only Ms. Sherrod was able to identify Mr. Bowman as being involved in this incident.
That's correct.
And you talked a little bit to Mr. Ballinger during cross. Turn the lights back on.
Ladies and gentlemen, I'm going to turn the lights on.
I'll probably ask you to turn them off again, but turn them down. But, sorry. When you were on cross-examination with Mr. Ballinger, there was a discussion about you needing corroboration to take certain acts, right?
Yes.
But in this incident, with Gerald Bowman being identified as being someone that assaulted someone, there's only one witness in your investigation that identified Mr. Bowman as being involved, correct?
Yes.
Right? With the exception of Mr. Hood strolling in here the first day of trial and saying that my client was involved, right? That'd be the only other identification out there.
I don't remember him saying that, but
That's okay, that's fine. Let me ask you something, Detective, do you know what time the Phoenix Police Department first became aware of this incident?
I don't remember the exact time. However, I believe it might possibly be documented somewhere in the report, either by Officer Berglund or in my original report.
Okay, do you know what a CAD report is?
Yes, I do.
Would that indicate to you when the person called in?
Yes.
Okay. Detective Santos, if I were to show you a CAD report, would that indicate to you what time someone called the Phoenix Police Department and what time people would dispatch?
Yes.
And that would refresh your recollection. May I approach the witness here?
Yes.
And that, I'm showing you exhibit 252, right?
Yes.
Okay, and what is that?
Well, it looks like a printout of a CAD incident that's dated February the 25th, 2015. And it shows that a priority 2 call was received in military time, 1934 hours.
On what particular date? That goes back to January 24th.
Responded at 1934 hours on January the 24th.
2015?
Yes.
I apologize, Your Honor, I'm gonna have to ask you this. Can we give him the lights again briefly?
Yes?
Santos, I wanted to show you 215, or excuse me, Exhibit 216 again. You recall seeing this one, right? Was that a yes? Recall seeing this?
Yes, I do.
And this was presented on January 28th, so 4 days after the incident, right?
Yes.
Do you recall Mr. Hood complaining about this particular lineup?
No, I don't recall that.
You can keep them dim, Your Honor.
Keep them dimmed?
Yeah, I'll get to it here in a minute. So back on January 24th, 2015 was the first opportunity you had to speak with Ms. Sherrod and Mr. Hood about this incident, right?
Yes.
Do you remember Ms. Sherrod even mentioning the word Instagram that particular day?
Yes, I do.
Did she tell you that she had identified someone from Instagram that day?
Sorry, could you repeat that?
Did Ms. Sherrod tell you that she had identified some suspects from an Instagram photo on January 24, 2015?
Yes, she did.
And so, but in your report, you documented a telephone call 2 days later where she said she could identify some folks, right?
Sorry, I didn't hear you on this.
Did you also talk to her again by telephone on the 26th, where she mentioned that she saw some people on Instagram that she believed were involved?
Yes.
And then you set up a time to meet with her on the 28th? Right. And she showed you what's been marked and is admitted as 81, right? Does that look familiar?
Yes.
And how much do you, this is a broad question, but how much do you know about Instagram and how it works?
Very little.
Okay. Did she also show you what's been marked and admitted as 82?
Yes.
Do you recall whether she was able to pick Mr. Bowman out of this particular picture?
I don't think that she was able to.
Turn it back up, Judge.
Ladies and gentlemen, I'm going to turn the lights on.
Now, you talked on direct about discovering that Mr. Bowman had some type of presence in Arizona the particular weekend of January 24, 2015?
Yes.
And was that some type of temporary or permanent residence here?
Oh, I believe that was a temporary residence.
Did you attempt to go out to whatever residence this was, like you did with the twins?
No, I did not.
All right, and at least initially, Mr. Hood informed you that he knew the twins, and he also knew Julius Kane.
That's correct.
Right, but at that time, he didn't say he knew anything about Gerald Bowman.
That's correct.
Were you aware of Mr. Hood, or Ms. Sherrod for that matter, identifying Mr. Bowman to Officer Berglund at his initial interview?
I believe that she had informed him that she had identified the persons involved in the incident through photographs that she had obtained through Instagram.
And you believe that's in Officer Berglund's report?
Well, I don't recall if it's in his report, but I I do know that that information was provided to me in the informational briefing conducted by Sergeant Westover.
All right, so would you be, well, let's just talk about reports and how complete they're supposed to be. Something as important as that, as identification of a witness, is going to be pretty important, correct?
Yes, it is.
Including the source of where that came from.
Yes.
All right, so would you be shocked to learn that there's no mention of Instagram in Officer Berglund's report?
No, I would not be shocked.
Now, you can keep the lights up, Judge. Or, well, no, let's see. Now, Ms. Sherrod, from this particular exhibit, was also able to identify Chris Melendez as being involved?
Yes.
Okay, but later, during the investigation, you presented her with a lineup with Mr. Melendez's, with a known picture of Mr. Melendez, correct?
Yes.
And she was not able to pick Mr. Melendez out of that lineup.
No, she was not.
And did she ever talk about Mr. Melendez having anything covering his face?
No.
Right. But the person she identified as Gerald supposedly had a bandana across the bottom of their face?
Yes.
Do you recall Ms. Sherrod telling you anything about the hair of the person she identified as being distinctive, the person that she identified as Mr. Bowman?
Yes, she indicated that it was a box type of haircut, flat on the top and straight on the sides.
So the hair and the bandana were the two most important things that you noted in your report from your conversation with Ms. Sherrod, right?
Well, those were two of the things that she identified, yes.
Did you note in your report anything that she talked about being distinctive with regard to this person's eyes or ears?
No.
Now, speaking of going back to Mr. Melendez, you never, Mr. Halal, Mustafa Halal, talked about an individual that he saw there that had some boots on,
Yes.
and they were, I guess, Timberland-style boots,
Yes.
beige or yellow.
Yes.
And he also said this person was about 5'8", 5'9",
Yes.
significantly shorter than the twins.
Yes.
You never showed any lineup with a known picture of Chris Melendez to Mr. Halal, correct?
I don't think so, no.
And Ms. Sherrod never talked about any of the clothing that, I guess for lack of a better word, this third person other than Chris Melendez and Julius Kane had on, right?
Well, she did talk about someone having a bandana that was an army type.
That was a bad question because I should have said, or that had on the bandana. So, and she said, she described that person as having a lighter skin complexion, correct?
Yes.
All right. And Do you know how tall Julius Kane is?
From the research that I have seen, he is approximately 6 feet 2 inches and about 245 pounds.
From any of the Instagram photos that you reviewed that Ms. Sherrod provided to you or that you observed from any of the social media detectives that helped you, did you ever see any photographs of Gerald Bowman with a bandana?
No.
Now, back on January 26th, again, 2 days after this incident, you also you spoke again with Mr. Hood, is that right?
Yes.
Was that the first time that Mr. Hood mentioned somebody with a bandana?
Yeah, I'm pretty sure it was.
Was this before or after you spoke with Ms. Sherrod?
That was afterwards.
Did you show Mr. Hood another lineup that particular day?
I believe so, yes.
And did he mention it having any trouble or complaining about that particular lineup?
I don't recall him complaining about it.
All right, and you interviewed Mustafa Halal how many times?
I believe I interviewed him twice.
Okay, and he never really described anybody to you other than well, he talked about the guy that we just talked about with the boots, right?
That's correct.
Now, is it your understanding that that same person, he also talked about somebody that had on like a dark sweater or a blue sweater? Recall that in your report?
Yes.
Is it your belief that, or your understanding that that the person with the boots is the same guy with the blue sweater? Or the dark sweater?
Yes.
But he didn't describe this person as having a bandana on his head or mouth or anything like that?
No, he didn't.
Now, Detective, were you ever made aware that Mr. Bowman presented or listed a defensive alibi as a defense to this matter?
Yes.
And what steps, if any, did you take to investigate whether that might be true?
Well, some of the information that I had received was that it was indicated to me that he was not anywhere near the crime scene on that particular date and time, and that he was at a shopping center, and that he did quite a bit of shopping that day, and that he also had gotten a haircut from a specific person. So I had asked if I could have that information, the shopping center, and the person who was supposed to be cutting his hair, and if there was any type of receipts that would document that he was somewhere else, and anybody else that would be able to corroborate that information. When I started to conduct that investigation concerning his whereabouts, I had contacted this shopping center and I spoke to someone in the security department, and they indicated to me that they had no video surveillance cameras at the shopping center. And
But let me stop you, but like you said earlier that there was you reviewed some evidence of, what were they, electronic receipts? Or you tell me what indicated that he was out shopping that day?
that information was given to me.
Okay?
So my response was that I want to be able to see evidence that shows this person was shopping. So if they've got receipts from a particular store that show a date and time, then that's what I need. And I took it upon myself to find out from the security department, do they have cameras there? And I also wanted to find out who this person was that was supposed to be cutting his hair on that particular date and time. And none of that information was provided to me at my request. I received none of that information.
With regard to this video surveillance, I guess, that's at the mall, was it your understanding that well, let me ask you this. Do you know whether or not they keep records of every single day of video for, like if someone's out shopping today and they're recorded, do they keep that video digitally or videotaped forever?
That's specifically what I had asked. What was the time lapse for the loop of the video surveillance?
Well, let me stop you there. What do you mean by looping?
Well, that means anything, if there's a security device, it's going to have so much memory depending on what was installed in it. So some cameras can record 24/7 and have a very limited amount of information unless they have quite a bit of memory. If they're only recording by motion sense, then there's probably going to be a lot more memory for more days and weeks and so on. So I had specifically asked the security department for any type of information that would show how much time period before this loop starts all over again and records over anything that was previously recorded.
And what was that loop period?
Well, it was indicated to me that they didn't have any video cameras installed at that facility.
All right, so, but you did have, again, some evidence that was presented to you that showed that Mr. Bowman was out shopping. Do you remember any type of time notation about the last time he was shopping at the mall?
Anything that was, I don't remember anything in detail that was presented here in court that I heard, but I know that it was mentioned.
Let me have a moment, Your Honor.
Yes. Ladies and gentlemen, I'm going to turn the lights on.
May I approach the witness, Your Honor?
You may.
I'm going to show you what's been marked as Exhibit 255. Is that the document you were referring to?
I've never even seen this document before.
But you reviewed some, you reviewed some document that indicated to you that Mr. Bowman was out shopping at a mall near the time that this incident occurred?
I never reviewed any document concerning.
sorry?
I never reviewed any document concerning his shopping.
Okay. Have a second.
Yes?
And Detective Santos, with regard to Alonzo Hickerson and this issue about I guess, what could be construed as perjury, we weren't made aware of that until after, or you weren't made aware of that until after our opening started, right?
That's correct.
Okay. Nothing further, thank you.
Redirect?
Thank you, Judge. Detective Santos, I want to talk to you a little bit about some questions you've been asked on cross-examination regarding witnesses, specifically Eric Hood and Sharika Sherrod, in terms of recorded interviews you took from them and when those happened. So you were asked a lot of questions about the amount of times that you interviewed Mr. Hood, correct?
Yes.
And the defense attorneys have all inquired as to specific statements given at certain times over the course of the 3 to 4 interviews you conducted of him.
Yes.
Same goes for Ms. Sherrod.
Yes.
They asked a lot of questions about when she stated certain things to you in relation to, was it her first statement, second statement, third statement?
Yes.
My first question to you is the CAD report, which was showed to you earlier, I believe is Exhibit 252. You indicated on this, it had a time when the 911 call was made, and which is that's the action that triggers Phoenix Police's response in this case, correct?
Yes, it is.
Okay, and you've had the opportunity, I would assume prior to trial, to have listened to the 911 call in that case?
Yes.
And based on review of that call, it is true that Ms. Sherrod indicated the Morris brothers were involved in this when she called 911.
Yes, that's true.
You've also had the opportunity, as was discussed numerous times on cross, to be privy to what witnesses have said in this court because you have the distinction of being the case detective, correct?
Yes.
You have the right to be sitting in here.
Yes.
Do you recall that numerous witnesses indicated that Ms. Sherrod, prior to leaving the Arch facility, had told individuals that it was the Morris twins? It was the Morris twin. Did she make those statements to individuals on scene?
Yes, she did.
Now, we've showed the maps in terms of, and I can go get the exhibits if you want to refer to them, from Mr. Hood and Ms. Sherrod, and on direct, we talked about how, in hindsight, probably wasn't the best map to show them because there had been an addition to the complex. Do you recall talking about that?
Yes.
And in Ms. Sherrod's statements to you, from her first statements through to her last statements, she indicated an area of the fighting that had occurred that Mr. Hood said he did not recall or did not remember or did not happen. Is that right?
That's correct.
And she was consistent in terms of what her statements were to you in terms of what she saw prior to going in to get the coaches.
Yes.
And she indicated to you that that area that she had mapped out in those exhibits over by the, what would now be the new parking lot, but over by the picnic tables, was the area she saw Mr. Hood be assaulted prior to going in to get the coaches.
Objection, Your Honor. Leading.
Sustained, rephrase.
Did she indicate that to you?
Yes, she did.
And that was before or after, Detective, she went to go get the coaches, that she said she saw that?
That was before.
Now, defense has asked you questions about upwards of 37 named individuals in the police report who were at the Arch facility that night.
Yes.
You had an opportunity, or other detectives had an opportunity to speak to some of those individuals.
Yes.
And I want to talk generally about the people you contacted. A number of those people were basketball players from the games that had been occurring, is that correct?
Yes.
When the defense asked you questions about, none of those individuals indicated to you that they had seen anything to corroborate what Ms. Sherrod had stated. Do you remember being asked that question?
Yes.
Is it true, Detective, that a number of those individuals reported seeing nothing at all?
Yes.
Some of those individuals indicated they were loading up in vans in the parking lot at different areas.
Yes.
Now, there was some discussion about your investigation and what you knew when you knew it. And so I want to give you that context for my next question. You go to the initial briefing and then you take the first initial statements. You were aware at that time that this case had the potential to be somewhat high profile in the sense that there were public, quote unquote, figures that were involved in this, people the public would know.
Yes, I was aware of that.
You knew that the first night.
Yes.
At some point during your investigation and work of this case, did you become aware of a financial aspect or financial component to some of the investigation you had done?
No.
Okay. Were you ever aware that there had been a civil case filed by the victim in this case?
No.
Okay. Were you ever aware that the victim had civil attorneys?
Well, there was, I know one person that had called me and told me that he was the attorney representing the victim.
Let me ask you this question. We talked a lot about your investigations throughout your career. Have you ever investigated a case where someone was assaulted by a group and or jumped, something generic like that?
Yes.
Have you ever had a case where the victim of an offense like that could not identify one or more of his attackers?
Yes.
And in this case, when you talked to Mr. Hood, he indicated to you, rather forthright, that he knew 3 of the people he thought were involved in this case.
Yes, he did.
Did he indicate, and I want to be clear about this,
that he knew the other two, but just couldn't remember their names, or what did he say as to the other two individuals?
Well, he didn't know them by name, and he didn't know who they were.
And I'll go through some of the lineups if need be, but we've shown a lot of them that were given in the first couple days after the offense. Then there were some shown in March. Like I believe Mr. Melendez's lineup wasn't shown until March of that year. Does that sound about correct to you?
Yes,
As part of the investigation surrounding what had occurred on Arch on January 24th, you had to figure out the actual identities of the two individuals that the victim was saying he didn't know, but had given descriptions for, correct?
yes,
Did that have anything to do with the fact that while Melendez's lineup was not done until March?
yes,
What I mean by that, it might not have been a clear question. You didn't have enough information at the time, say January 26, 27, to know that Christopher Melendez was a possible suspect.
that's correct.
And whenever you, in the progression, at some point come March, you had what you believed was enough information to implicate he could possibly be involved, and therefore showing lineups at that point, right?
Yes,
Approach the witness with, let me ask you this, Detective. The first initial interview you took of Eric Hood, your recorded statement, occurred when?
that was a little bit after midnight on January the 25th.
And that was roughly an hour. We've talked about some of the details provided in that,
Yes,
including what we've gone over. He said 5 people were involved. He knew 3, he didn't know the other 2.
that's correct.
And he mentioned the 3 he knew by name,
Yes,
including Mr. Kane as well as the 2 Morris brothers.
yes,
Approach the witness with Exhibit 244.
You may.
You were shown that on cross-examination. That's reported to be the call log for Mr. Hood.
yes,
And we talked about a number of calls that the defense asked you about from Mr. Hood and Hickerson. Hood calling Hickerson, Hickerson calling him, documented in that call log,
yes,
upwards of like 10 or 11 on the 25th. Does that sound right?
yes.
What are the times of the first calls on the 25th? If I can approach so I can see it as well.
Yes.
And then I'm only referring to Mr. Hickerson.
According to this document here, the first outgoing one from Alonzo, or to Alonzo Hickerson, was dated January the 25th, 2015 at 6:15. I'm sorry.
We're going to go over to the UTC time that have been explained off to the right.
Okay. On this particular one, on the 25th, the time that this outgoing call went out was 11:15 in the morning.
And then this exhibit displays a number of calls between Mr. Hickerson and Mr. Hood and Mr. Bowman and Mr. Hood on the later in the 25th, starting at around 10:50. Is that right?
Yes,
And those are the 8 or 9 calls that are consecutive calls back and forth between those individuals.
yes, they are.
The bulk of the calls on the 25th occurred at night.
Yes.
Yeah, just could object to that. I think it misstates the prior testimony that
Well, what is the basis of your objection? Why don't you approach for a second? Mr. Fisher's going to ask you a different question.
terms of, we talked a little bit about some statements that you were aware of that had been given by the witnesses prior to the interview, such as, let me ask you this. Did you know the contents of the 911 call before you talked to Ms. Sherrod or Mr. Hood?
I just had very brief information concerning the 911 call.
Well, prior to your taking any initial interviews from them, were you aware that Mr. Hood was indicating he knew 3 people and who those 3 people were?
Yes, I learned that in the briefing.
Okay. Defense asked you some questions, and we were talking a little bit about some investigations you've done before, like I used the example of like a jumping or something like that, where someone couldn't make an identification. Do you remember me asking that question?
Yes.
Is it common or uncommon for you, in terms of some of your cases, to make presentations or a case summary about what it was you've uncovered with individuals from within your own department?
Well, it doesn't happen real often, but we do that from time to time.
In the context of what the defense asked you, they indicated there was meetings before where members of your department as well as the county attorney's office were present. Do you recall being asked that?
Yes,
And you recall saying that there was such meetings?
yes.
Is it uncommon or common for you as a detective to meet with the county attorney or the prosecutor prior to the case initiating? Does that happen a lot?
Yes.
Let me ask you this. Who decides to submit a case for criminal charges?
That's me. As a case agent, I would decide if a case is going to be submitted to the county attorney's office.
So you're a Phoenix police officer, you would make the decision in this case that was yours whether or not to submit the case for charges.
Yes,
And that's what you did in this case.
yes, I did.
Does the victim decide whether or not charges are going to be submitted?
No,
What about a witness? Does a witness decide whether charges are going to be submitted by the Phoenix Police Department?
no.
Now, Mr. Eckstein had asked you yesterday, I believe, about that you had done a lot of work in this case. You logged a lot of overtime hours.
Yes,
Talked about some of the resources you had at your disposal to investigate the case. Do you remember these questions?
yes,
Mr. Eckstein then asked you that you would have worked hard, so if there was any inculpable evidence, meaning inculpating the defendants, you would have found it. Do you remember being asked that question?
yes.
And your response to that was what?
That, yes,
Okay. And in this case, did you believe that you found evidence that inculpated the defendants?
yes,
Okay. Now, in terms of, let me ask you this. During the course of your investigation, you uncovered information that there was a relationship between Eric Hood and the 2 Morris brothers as well as Julius King.
yes,
And that was in information more than just Mr. Hood telling you that.
yes,
Other sources of information.
yes.
We've seen some photographs, is that correct?
That's correct.
You also had conversations with some individuals, other witnesses in this case, such as Thomasine Morris.
Yes,
And during the course of this investigation, did you find evidence that indicated that Mr. Hood had let an individual close to the Morris brothers let him know where he was going to be that night?
yes.
Who was that individual?
That was Thomasine Morris.
And in reviewing the 911 calls, and I can show you the text messages that you reviewed, documenting the conversation between Mr. Hood and Thomasine Morris. If you want to refer to those when I ask this question, I can provide that. That was roughly 2 hours before 911 calls were triggered in relation to this case. Does that sound about right?
Yes,
So we let her know at 5:30 where he was going to be, and 2 hours later, he's calling 911 on the way to the hospital.
that's correct.
Now, the first patrol officer that responded, what was his name?
That was Officer Berglund.
And is it common, Detective, that in a case such as this, where you're not necessarily responding to a crime scene, you're responding to a hospital, that the first responding officer tries to take as much information as he can to prioritize, A, what kind of case this is, and B, where's my next call gonna go?
That's correct.
Other than the 911 call, Officer Berglund wouldn't have had any information given to him that you know of as the case agent prior to walking into the hospital and trying to figure out what had transpired.
That's correct.
And as I believe was asked of you in cross, I mean, there's no indication that any of his initial statements taken by that officer to Mr. Hood or Mr. Rod were recorded, correct?
That's correct.
Is that uncommon in your experience that a first responding patrol officer wouldn't record the initial information he gets on scene?
It's not uncommon for those contacts to not be recorded.
You were asked questions on cross-examination about the confrontation calls, whether you were present or not present during some of those calls. And I just want to ask some clarifying questions so I understand what it was you're indicating. First of all, whose idea in this case was it to initiate confrontation calls?
That was my idea.
And correct me if I'm wrong, and I think it's worth going into a little explanation of these calls. What is the perceived benefit from you as the investigator to making a call, in this case using Mr. Hood, to call people that he knows versus you trying to call them? Why do you think that could be helpful?
Well, there's a very good reason why, because in this particular case, I already knew that there was a relationship between Hood and Thomasine, because he had indicated that they had been friends for quite a long time. And that he also indicated, he texted her and told her that he was going to be at the Arch facility at a particular date and time. And since this is the mother of the twins, and they were at the Arch facility, and this incident occurred, there's a very strong likelihood that because of their relationship, Mr. Hood and Thomasine, that if she believes that she's speaking to him in confidence, that she might possibly reveal information that would be beneficial to this investigation.
So you believe as an investigator that there's a potential benefit to letting someone, like in this case Mr. Hood, make that phone call versus you, in terms of what the potential witness might say on the phone?
Yes,
Fair to say you would perceive that maybe that person wouldn't have as much of a guard up in terms of talking to a police officer?
that's correct.
Would it be fair that a lot of the individuals in this case whether it was at the Arch facility that night or specifically some of the individuals we've heard from in court, Jacob Miller, Gustavo Law, those individuals upon first police contact did not appear to want to be involved in this incident whatsoever. Is that correct?
Yes, that's correct.
Did you experience hesitancy in trying to get anyone to say that they saw anything that night?
Objection, Your Honor, this is way
Overruled. You can ask to approach when it's over.
thanks.
Would you like the question read back?
Yes, please.
Could you please read back the question?
Question is, did you experience hesitancy trying to get anyone to say they saw anything?
So I'm going to rephrase that question now that I know the context, but we talked, or you talked on cross, I sat and listened, about a number of individuals present at the Arch facility that night, and defense said none of them could corroborate Ms. Sharika Sherrod's account. Do you remember being asked that question?
Yes,
I then asked you a question about, isn't it true that the majority of those individuals reported seeing nothing?
that's correct.
The individuals, and again, we're talking about those 37 individuals discussed on cross. Individuals who reported seeing it, whether it was a group running or anything other than nothing, let's start with that. Did they have hesitancy in talking to you at all?
Yes,
So going back to my question now, you felt it was going to be a benefit to try and do confrontation calls with Eric Hood calling potential individuals that had information, including Thomasine Morris and Alonzo Hickerson, without them knowing that you were being either in on the conversation or that the conversation was going to be recorded.
that's correct.
Because the goal of a confrontation call, you don't announce that this is going to be recorded, is that right?
That's correct.
That requires, in order to do a confrontation call, in this case, a level of compliance, let's say, by the victim. Because you can't force him to make this confrontation call.
That's correct.
So you have to ask for his help.
Yes.
And you asked for his help in trying to set up a confrontation call with Thomasine Morris, is that right?
Yes, I did.
And you asked for his help in trying to set up a confrontation call with Alonzo Hickerson, is that right?
Not initially, but then afterwards, yes.
And those calls, which we've discussed about on cross-examination, both resulted in some sort of recordings. It's just there were issues with how long the conversations were recorded in both.
Yes,
But your belief or testimony is that the decision to initiate confrontation calls at all came from you.
yes.
If I could have just a minute.
Yes.
Judge, if we could briefly,
Yes, would you bring Exhibit 184 up when you come? The call log. Do you have the call log?
I do not have all that.
Isn't it?
We just have a minute, Judge.
Yes.
In terms of the identifications made of Mr. Bowman, you showed lineups to both Ms. Sherrod and Mr. Hood, is that correct?
Yes, I did.
And it was only Ms. Sherrod that identified Mr. Bowman.
Yes.
Did you have any information to indicate that prior to the assault, prior to the 24th, that Ms. Sherrod or Mr. Hood knew Gerald Bowman?
No.
And is it your testimony that you were never provided with any document evidence to substantiate any sort of alibi, meaning that documents, I'm not saying word of mouth, a document that says this is where he was. I was either at the mall or I was somewhere else. You never reviewed any documents like that?
No, I didn't.
And were any provided to you?
That's correct. There were no documents provided to me concerning that.
And have you had an opportunity to review the video of the basketball game that night, the actual game that was being played at the Arch?
Yes.
In reviewing that, did you feel that, in terms of what you were doing in your investigation, you had a person, Eric Hood, and Ms. Sherrod saying 5 individuals did this?
Yes,
Correct?
that's correct.
Did you feel that in reviewing the evidence, there was any substantiation to the fact that there were 5 individuals coming into the gym that night?
Yes.
And I use the word substantiation, but what I mean by that is you had eyewitnesses saying one thing, you looked at the video, and did you believe the video corroborated what they were saying in terms of the number of individuals there that night?
Yes.
No further questions, sir.
Yes? Mr. Eckstein has a brief recross.
Detective, a couple questions. In response to Mr. Fisher's question about why you would have an individual make a confrontation call with somebody they have a relationship with, you answered that you wanted Mr. Hood to have a confrontation call with Thomasine Morris specifically because she had sent a text message to Mr. Hood a couple hours or so before the altercation that's the subject of this case. Is that right? Yes. And so I just want to ask, do you know whether in that confrontation call that subject ever came up? The sending of that text message?
No, I don't believe it was.
So as far as you know, Mr. Hood never asked Ms. Morris in that call about her having sent that text message and the potential connection of that event to this case, correct?
And you're talking about the conversation that he had with Thomasine for about 17 minutes, correct?
Correct.
Okay. In almost the entire conversation was pretty much one-sided with Mr. Hood speaking only. And I don't recall if there was any information where they discussed receiving or sending text messages.
Mr. Hood never asked her about that in this call, right?
I don't think so.
Nothing good.
Redirect.
Do you remember the date of the confrontation call with Mr. Hood and Ms. Thomasine Morris?
No, I don't.
You don't? Is that your response?
I don't remember the date that it was made.
take a look at 180, which is transcripts, and see if that refreshes your recollection as to when that call was initiated.
Yes, that was dated February the 11th, 2015.
And in terms of communication, I guess my question is, communications between the two of them prior to this confrontation call?
I wasn't aware that continuing to have contact after this incident.
I'm trying, maybe I'm not asking that question correctly. Do you recall seeing screenshots, Detective Santos, from Eric Hood's phone where he documented the text conversations he had starting on the 24th into the next few days afterwards with Thomasine Morris?
Yes, I recall that.
So, based off of that information, would you agree with me that there are texts preceding after the 24th in those screenshots as well, meaning into the 25th and 26th, between Eric Hood and Thomasine Morris?
Yes.
So you were aware that after the incident had occurred on the 24th, that they were at least still in a line of communication between the two of them?
Yes.
No further questions.
Any questions of this witness from the jury? Columbia?
Thank you. Sir,
Did Sharika Sharad show or tell you where the incidents occurred while you were at the Arch facility when you arrived there after you finished your investigation at the hospital the night of January 24th and 25th?
No.
Did either of the Morris twins ever admit to knowing Eric Hood?
No.
Did either of the Morris twins ever provide you or another investigating detective an account of what happened at the Arch facility on the evening of January 24th, 2016? Yes. Sorry, let me ask you a different question. When it comes to confrontation calls, specifically between Eric Hood and Thomasine Morris and Eric Hood and Alonzo Hickerson, did you give any sort of prompting to Mr. Hood, such as conversation topics or a list of questions to ask?
Yes, there's generally we'll go ahead and try and give them advice or coach them as far as what type of information that we're looking for, but it's specifically up to the victim on how he or she is going to obtain that information. For example, the way they talk, the subjects that they bring up, and the length or duration of the call.
When Mr. Hood stated that he wasn't sure if Markeith Morris was hitting or kicking him after 9 times of stating he was absolutely positive that Markeith was, did you follow up with Mr. Hood as to why his statement was now changing?
Well, I do recall when, after he had told me that to see if he could give me any other type of information, but I don't recall specifically him saying the reason why, other than he was just not 100% certain that he could say that Markeith Morris was involved in the incident.
There's a second portion of this question. I'm going to read a portion of the first question that I just read to you to provide context to the second portion. Did you follow up with Mr. Hood as to why his statement was now changing? If not, why?
Well, yes, I did. And his answer was that he was not 100% certain. So, yes, I did to a certain extent inquire as to why he had changed his statement on that particular incident.
Any follow-up on the jury questions, Mr. Fisher?
Yes, Judge. Detective, as to the question regarding whether you showed, had Sharika Sharad show you the areas where she had seen the assault after the hospital that night, when you all potentially could have been at the same location, your response was no, is that correct?
That's correct.
Did you ever ask her at that location to show you and walk you through that area?
No.
Your review of the what she had seen in terms of having her show you anything was limited to the maps that we've already discussed,
That's correct.
where she drew on them?
Yes.
Nothing further from the state.
Mr. Eckstein?
Detective, as to the question and answer regarding whether the Morrises ever told you that they knew Eric Hood, you went out to their home, I think it was the 11th of February, is that right?
Yes.
That was the only time you had any contact with them, is that correct?
That's correct.
Prior to that date, you and I had spoken maybe 3 times over the telephone, is that right?
Yes.
So you knew at that point that I was representing the 2 of them, correct?
Yes.
Judge, I would object to relevance at this point.
Please. Mr. Eckstein's going to restate his question. I know we're overdue on our break. I'm just trying to get through this witness. Are you okay? Okay.
The detective, you and I had spoken a couple times before the occasion you went out to the Morris's home, is that right? And you and I were in discussions about potentially setting up an interview of Marcus Morris and Markeith Morris, is that correct?
Yes.
And while we were talking about that, you went out and interviewed them, correct?
Yes, I did.
And following that occasion that you've described, when you went out to the home, you made no more requests of me for information regarding Marcus Morris or Markeith Morris, correct?
After that date?
Correct.
That's correct.
Any follow-up, Mr. Ballinger? No. Mr. Lackey?
No, Your Honor.
Mr. Fisher?
Hold on one second, Judge. Detective Santos, we talked about the February, I believe it was 10th date that you went and you saw the 2 Morris brothers at their house in Paradise Valley. Does that sound correct to you?
Yes.
Mr. Eckstein asked you about, in the days prior to that, communications between you and him trying to set up a time to get statements from the Morris brothers.
Yes.
Was it in relation to one Morris brother or both Morris brothers that you were communicating with Mr. Eckstein?
Both.
And was it one attempt or multiple attempts to try and set up an interview before you went out to Paradise Valley to talk to them?
It was at least 6 times that I had either spoke to him or left voice messages for him.
And throughout those communications, you were not ever, you were trying to set up a time to meet with the Morris brothers. Were you ever successful in speaking with Mr. Eckstein, accomplishing that? Through him?
No.
So you went out on the 10th and you interviewed them that day? And you did not tell Mr. Eckstein that you were going out there that day?
No.
And to be clear, as it relates to this jury question, they never told you that they knew Eric Hood when you went out there and talked to them that day?
That's correct.
And you asked them that directly?
Yes, I did.
No further questions.
Any follow-up from the jury? Thank you, sir. You may step down. Watch your step. All right, ladies and gentlemen, the long-awaited 3 o'clock break is here. The admonition will continue to apply. Ladies and gentlemen, we're going to take a little bit of a longer break, probably about 20 minutes. All rise. We are on the record in CR 2015-00167-1-001, 003, and 004. State of Arizona versus Gerald Bowman, Marcus Morris, and Markeith Morris. We're in the presence of all counsel, all defendants outside the presence of the jury. Is the state resting outside the presence of the jury?
Yes, Judge.
Any motions from defense?
Yes, Your Honor, I have a Rule 20 motion it's based on.
I can't hear.
Oh, just a minute, let me turn your mic on, hold on. Go ahead.
The standard for Rule 20 is whether or not there's substantial evidence that a rational fact finder could find against a defendant. And in that case, we've heard the evidence. I don't believe that there is that evidence. Regarding Ms. Sherrod, who directly implicates or says that Markeith Morris was involved in the matter, her testimony was not corroborated by anybody. The victim, who literally says he could, literally almost to the point he could tell these people apart in his sleep, said that he was struck at the door and sprinted over 100 yards, that there was no assault anywhere where Ms. Sherrod described it. 30-odd witnesses who were interviewed by Detective Santos, none of them say that there was any kind of assault in the area where she said that it happened. Her testimony regarding coaches Halal and Miller, she said that there was a confrontation at the end of the driveway. They were told to stop. None of that has been corroborated. It's all incredible evidence. So in terms of that, just the Sherrod parts of this, Your Honor, there is substantial evidence, is evidence that is weighty enough such that a rational fact finder looking at it could make a determination that there's guilt beyond a reasonable doubt. That is not the case here. There's not one single witness that corroborates what she said. On top of it, it's outrageous. It's unbelievable that we had 2 witnesses come in here, raise their right hand and say to you that they were solicited to lie about implicating the Morris brothers. And even though Ms. Sherrod and Mr. Hood did not admit that they were solicited to lie, there are text messages, rife with text messages indicating that from Ms. Sherrod, because she was going to be a witness in this case, LOL, she was going to make $20 million because Mr. Hood was going to get a settlement. You have to take that into account regarding her credibility, in addition to all of the other facts that suggest that what she says never happened. Similarly with Mr. Hood, he actually says literally 9 times, yes, he was involved, yes, he was involved, yes, he was involved. Oh, by the way, no, he wasn't involved. In fact, he was 250 feet away. So in terms of the actual touching of the assault, completely beyond the pale. Even if you, and I don't believe you can credit Ms. Sherrod, and that's frankly for Rule 20, that's why it's there. Your judges are supposed to do that. You're supposed to look at this in terms of substantial evidence from a rational fact finder. In terms of the accomplice theory, there is zero evidence that there was any agreement, any solicitation, any aiding and abetting. For the first time ever, we heard yesterday that perhaps Markeith Morris was a lookout. But there's no evidence at all in this case from the state that there was any kind of agreement, any kind of solicitation, any kind of aiding and abetting. It's a wish and a prayer. The only thing they have is literally some testimony from Eric Hood that several years before there was a misinterpreted email by Julius Kane that resulted in there being a split in the relationship between the Morris brothers and Eric Hood. But motive is not evidence. Motive is, and in fact, that's what the instruction says. You know that better than I do. Motive is not evidence. It's just maybe something that can illuminate evidence. But here, there is nothing to illuminate. There's no evidence to illuminate. This is, frankly, in some respects, this should be dismissed because of the solicitation of perjury. This has permeated the entire case. It's infected the entire case. And on that basis alone, everybody should take a pause and say, are we really going to allow this to go forward? Putting that to one side, there is zero substantial evidence that a rational fact finder could rely on in order to find beyond a reasonable doubt that Markeith Morris was involved in this.
Is there any other defense counsel that would like to make a Rule 20 motion?
I would, Your Honor, on behalf of Marcus Morris. I'm not going to repeat all of Mr. Bellinger's comments as to Sharika Sherrod. I will adopt them and observe briefly that her description of what transpired is not just sort of inconsistent with the other evidence that the court has heard. It's entirely at odds with it. It's incompatible with every other witness who has come in here and testified has explained that nothing happened in the physical space where Ms. Sherrod identified 5 individuals assaulting Eric Hood. A space, I should say, that is now physically very different from the one that she described, using maps of a pre-remodeled space between the parking lot and the gym doors. Her statement is entirely at odds with that of the victim, Eric Hood. I can't imagine how her statement could be substantial evidence of anything. So as Mr. Bellinger said, substantial evidence, it's proof that reasonable persons can accept is sufficient to support conclusion of a defendant's guilt beyond a reasonable doubt. We're not just talking about a standard of evidence or an amount of evidence that would allow a finding of probable cause, reasonable suspicion, or something beyond that. But the court knows the high standard that we have in our system. So at some point, the court has to measure the quality of that evidence, and it's not enough to say that this person came in and took the oath and testified that if one were to believe what she would say, that would be evidence of guilt. I mean, imagine a situation where you have one person saying A and 99 people saying not A. I dare say that the one person who said A under that circumstance would not be substantial evidence that would allow a case to proceed and require a defendant to put on a defense. And in that case, when it's no reasonable person in that circumstance, the 99 against 1 could find that evidence sufficient and reliable to meet the standard of proof beyond a reasonable doubt. We don't quite have the 99 to 1 with Ms. Sherrod, but we have something approaching that. With respect to Eric Hood and his statements, I think there are two fundamental reasons that his statements inculpating Marcus Morris are not credible, and therefore a reasonable juror could not rely on them to find proof beyond a reasonable doubt. The first is the testimony of Mustafa Halal, who had indicated that upon coming out of the gym, he saw Marcus Morris runs down to the end of the property. The fight is over, and he sees that Marcus has never gotten closer, between 10 and 20 feet. Obviously, the court saw the distances that he agreed in court, approximately between me and the clerk's bench. If Mr. Halal is truthful in his description, then what Mr. Hood says could not have happened. And Mr. Halal, of course, has not only no reason to lie, he came in here and did a difficult thing, which is to inform all of us that somebody had attempted to suborn perjury and force or offer to pay him to testify against Marcus Morris and Markeith Morris. The second reason is that change in testimony from Eric Hood as to Markeith Morris. I think it's the evidence has shown that 9 times, explicitly, definitively, with great certitude, he said that Marcus Morris and Markeith Morris physically assaulted him. He has a telephone conversation with somebody or bodies, comes back and does a 180 as to Markeith. Immediately after that, as he explained in his testimony, I can't say I saw Markeith do it. He was somewhere, far away in the parking lot. That's pretty far away. But for sure, I saw Marcus do it. And now this is significant in 2 respects. So one is, he's obviously tying these 2 things together. He knows he needs to keep one of them in this case, one of them as liable or guilty in order to protect his financial interest. The second is how we know that he picked Markeith. Well, we've heard that Jacob Miller had multiple discussions with Alonzo Hickerson in the day and 2 days following the incident, including discussions where Miller described what he had seen. And we've heard Mr. Miller's in-court testimony, and that testimony is that he saw Markeith Morris. He did not see Marcus Morris, but saw Markeith Morris in the parking lot and didn't lose sight of him until the altercation was over. So that knowledge would naturally cause someone to understand they were not going to be able to prove Markeith Morris's involvement, but that, of course, left open the possibility of Marcus. And there's no question about what Mr. Miller's going to say, that Mr. Hood entirely changed his testimony on this subject, and that followed a conversation with a lawyer or some persons around the time that they would have learned this information, according to Mr. Miller, from him. So those are the only 2 pieces of inculpatory evidence, the statements of Ms. Sherrod, the statements of Mr. Hood, which taking out for a moment other concerns about credibility regarding the relationships, financial interest, other inconsistencies and fabrications that have come out through testimony. I think on their own, Ms. Sherrod, because of the other evidence, all the other evidence has come in, and Mr. Hood's, based on Mr. Miller's testimony and Mr. Halal's testimony, is not sufficient to be substantial evidence that would allow a rational fact finder to find proof beyond a reasonable doubt of Marcus Morris's guilt.
Your Honor, I would join the motions of both of my co-counsel, especially as it relates to the inconsistent testimony of both Hood and Sherrod. Particularly, really, there's been inconsistent statements made between both of them at different times, and including here at trial. We've got absolutely no corroboration that Mr. Bowman was even present, other than, again, the incredible testimony, if you will, of Ms. Sherrod. The only other corroboration was, again, from the incredible in-court identification made by Mr. Hood. The credibility and what they saw, what they perceived, has already, the motivations behind them, what we would feel would also extend to Mr. Bowman, and their credibility should be compelled to dismiss Mr. Bowman as well.
The state's requesting you deny the motions for Rule 20 from defense. Directed verdict for acquittal should only be granted if the evidence is such that
Can you sit down?
such that reasonable minds may differ on inferences to draw therefrom. the court is to motions in favor of the evidence in terms of what the state has presented towards the state. One of the things that I think is important that the defense are asking the court to do is remove from the province of the jury a judgment on credibility of witnesses, and asking you to say that no reasonable minds could believe anything that Mr. Rod say or Mr. Hood says. The state believes that based off of the eyewitness identifications from Sherrod and Hood, there is evidence to go forward that all of the defendants are principals, meaning hands-on in this assault. One of the things that, and we've had discussions about this prior to this case ever coming before Your Honor in what would have been a remand context, was all of these people, the 1 versus 99 that Mr. Eckstein's saying, that one person is saying this, 99 people are saying that can't be true. That is not what the evidence has shown in this case. That is not what the witnesses have indicated. They're trying to pose Mustafa Halal and Jacob Miller's testimony regarding what they saw after Ms. Sherrod had already witnessed the assault at the door and what she saw in the parking lot, and then went and got them. So they are not juxtaposed so that one can only be true and the other one must be false. The testimony in court was that those two individuals do not come out until Ms. Sherrod goes and gets them. Ms. Sherrod indicated she didn't go and get them until she had witnessed what she saw. So to try and prop up their testimony to discount against her is to lose context as to what the testimony in court was. In terms of the statements made by Mr. Bellinger in terms of someone prompting perjury, there's been no evidence in this case that either Ms. Sherrod or Mr. Hood tried to get witnesses to lie on their behalf. They denied those accusations. The offerings made in court were not offered for the truth of the matter asserted, but in fact were offered on the effect on the listener, Mr. Halal and Mr. Miller. I would also highlight for the court that despite what they said they heard, they both indicated that they came in here and told the truth. As it relates to the evidence moving forward on accomplice liability, you heard testimony in this court that Mr. Miller, upon exiting, yelled out to one of the Morris brothers who was looking down towards the skirmish, that Morris brother looked at him and didn't say anything back. He takes off running towards the skirmish. There's been evidence to indicate that all of these individuals know each other. All of these individuals were present that night. The circumstantial evidence, in jumping to Mr. Lackey and what he's arguing, you have a witness who identifies this person as being there. You also have circumstantial evidence which corroborates that there is a fifth individual. Ms. Sherrod identified that fifth individual as being Mr. Bowman. The state is requesting that you deny the motions as to all three defendants. The state believes that the credibility of these witnesses needs to be judged by their testimony in court here, not with offerings from defense counsel about what all these other potential people that we've never heard from and had no evidence offered for truth of the matter asserted for should be cut against their credibility. So the state's requesting you deny the motions.
Mr. Fisher, before you stop your argument, I know we talked last night off the record. What is the state's theory? Is the state alleging that Markeith Morris may have acted as a principal in the assault?
Correct.
You are advancing that theory based on Ms.
Yes.
Sherrod's testimony?
Correct.
And I know we spoke last night, but what is the state's theory regarding the accomplice conduct of Markeith Morris?
Obviously, relevant in this discussion, which is motive in terms of that these individuals know each other. That is not evidence of guilt, but there has been strong evidence linking all of these defendants together. The state's theory as it relates to Markeith is, one, setting aside the principal argument, correct, Judge?
Yes.
That he was a lookout for what was going on, that he knew and was present when this assault started, that he was watching as the assault progressed down the way, that he was standing there observing the encounter, which was basically a beat down of Eric Hood, that when individuals come out and ask what's going on, he then runs down to alert them. The assault does not stop until he is down there and those coaches make their way down there. So we believe that there is circumstantial evidence, given the associations of all these people, given the eyewitness testimony, that what he's looking at isn't his tires. He's looking at what's going on, and when called out, hey, what's going on, he takes off down there, and we believe there's circumstantial evidence to show that he alerted those individuals that the jig is up, people are coming, and then those people see people coming and stop the assault. So that would be the argument towards accomplice liability. There's also testimony from witnesses who cannot not identify individuals, that it is a group of 6 to 7 to 8 individuals engaged in the pursuit. Ms. Sherrod indicated that she believes Marcus and Markeith had run towards the victim at some point other than down at the street. We believe that the evidence from those individuals that can't identify who they saw running, again, circumstantially points to the fact that the 5 individuals, 2 of which have pled guilty, are acting in concert descending on Eric Hood. So it would be that he's engaged as an active participant as a principal, that he's engaged in the pursuit of Eric Hood, and that once they go down the street, he is engaged as a lookout in order for them to continue the assault of Eric Hood.
Any final word, Mr. Ballinger?
Your Honor, the case that I'm referring to regarding this Rule 20 standard is State v. West. And it's 226 Arizona 559 250 P3rd 1188. On all Rule 20 motions, the relevant question is whether, after reviewing evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. Substantial evidence is such proof that reasonable persons could accept as adequate and sufficient to support a conclusion of a defendant's guilt beyond a reasonable doubt.
What paragraph are you on?
I'm actually on paragraph 16, Your Honor, and it goes down to 17 and 18, but the critical components are the ones I just read to you. The state's theory is that Markeith may have acted as a lookout, but there was, when coaches Halal and Miller came out, they saw Mr. Morris. Halal says both Morrises. Miller says Markeith, and that he slowly started going down towards the Ramada. There's no evidence that he said, hey, there's guys coming, things that would be commensurate with a lookout. The evidence is that when they got to about, I think I was at where Mr. Schwartzstein is, back in the gallery, from the witness table, they saw the fight had stopped as they were approaching Markeith Morris, and there was a Q&A. Miller says, does this involve my kids? And Markeith said, no, it doesn't involve your kids. Halal said, what's going on? Or he said that Miller said, what's going on? And Markeith said, nothing's going on, and the fight was over. The whole lookout, there's no evidence. The fact that they know each other, that's the mere presence. That's why this is difficult for a judge in an accomplice theory. Accomplice is so amorphous. He was acting as a lookout. Well, there's no evidence. There's no testimony to that effect. There's nothing to indicate that whatsoever. You have him slowly going down to a Ramada, or maybe a little beyond the Ramada, some 75, 90 feet from the fight, with no comment whatsoever. Hey, there's a bunch of people coming. There's none of that. There's no evidence to that effect at all. In fact, the only testimony from Miller and Halal is that the fight was over as they approached, as there was the Q&A was going on, and as they were approaching the Ramada. Not that Markeith said, stop fighting, they're coming. There's none of that testimony. He talks about the 5 or 7 or 9 people that various people saw running down the street. We had Markeith and Marcus stand up at various times. Every one of those witnesses said that the persons they saw running were 6'3", 6'4", or shorter. And that if they had seen somebody that was 6'9" or 6'10", that would have stood out in their mind. Your Honor, Rule 20 is there because sometimes judges have to make tough calls. Sometimes they have to say, you know what, I look at this evidence and I see what Ms. Sherrod said, and you're allowed to draw inferences. We never said that Sherrod or Hood solicited perjury. It was Mr. Hood's confidant, mentor, that 2 people testified, and that is substantive testimony. Those have independent legal significance. That came in as substantive testimony, and my recollection, that there are at least 2 witnesses that were approached by Alonzo Hickerson to lie about what happened. And the inference, if there's an inference to be drawn, the inference can also be drawn, backed up by text messages, that Mr. Hickerson approached Ms. Sherrod and Mr. Hood and said, look, this case isn't worth crap if you only have the peon involved in it. You need to have the Markeith brothers, the Morris brothers. You have to have them in the case. That's an inference you can draw from the facts that are in front of you. The standard is substantial evidence that a reasonable person could accept to prove something beyond a reasonable doubt. That's not here. Rule 20 is in the books for a reason, and sometimes the court has to evaluate the evidence in light of that standard and make that call. And this is one of those cases.
Mr. Eckstein.
So two things. One, Mr. Bellinger had alluded to, and that was that with respect to Mr. Fisher's comment that, several witnesses saw multiple people running down there, the magic number of 5, Mr. Bellinger indicated. So one piece is, number one, the evidence exculpates Marcus Morris from having been part of that. Sometimes it's a bad thing to be 6'9", sometimes it's a good thing. It's a good thing when the people who run down there are clearly of different height than you, and that's what those 2 witnesses said. Then you have what Miller and Halal said, which was, of course, that the Morrises could not have been the people running down there because they were closer to the gym doors when they came out. To put another way, there's no evidence, none at all, that they were part of the group of however many individuals it is that were running down there. There's not a shred of evidence as to that. The second, the court didn't ask me about any connection on an accomplice liability theory as it relates to Marcus Morris. But I'll just touch briefly on what I guess must be the state's theory as it relates to the lookout for Markeith, or assuming, based on Halal's testimony, that Marcus was effectively in the same position physically when he came out. There has to be some evidence, plan, discussion, conspiracy, and something that holds together in some kind of rational way that would allow the state to articulate that sort of theory, that the brothers were outside there to enable the assault to go on. The evidence that has come in is that Mr. Kane confronted Mr. Hood at the door of the gymnasium. That at that point, nobody saw the Morrises anywhere. That Mr. Melendez came up and hit Mr. Hood in the head. And at that point, Mr. Hood began to run and ran 135 to 150 yards. The lookout theory, I guess, assumes that the individuals who were part of this would have known that the confrontation at the door would have gone in the way it did, such that somebody would have hit Mr. Hood, and Mr. Hood, instead of fighting back physically at that point, or simply falling to the ground, or not fighting at all, would have run 150 yards in the very direction that the Morris brothers happened to be, where they would then wait for 2 coaches, or I suppose any individuals, to come out. And then instead of trying to stop those individuals, they would then go down in the direction of where the altercation was already taking place. Mind you, out of sight from where they were. It's a theory, I think, that's not only based on any evidence, but circumstantially is just totally untenable. And I think the kind of thing that, again, would require the court to grant a judgment of acquittal if that is, in fact, the theory under which lies any argument as to accomplice liability.
Mr. Lackey.
Thank you, Your Honor. Judge, the state in its response talked about this other evidence being presented, circumstantial, if you will, that there were at least 5 people, and by, I guess, inference, that just by that fact, Gerald has to be one of them. The only person that can tie him into that, again, is Ms. Sherrod, whose credibility, again, it's been discussed amongst co-counsel, and her motivations for testifying have been laid out, along with Mr. Hood's.
Now, my notes reflect that Mr. Hood also identified the person sitting to your right as involved in the physical assault.
Understood. That's the only corroboration, Your Honor. That's it. Only, and again, this is an in-court, not, the only time he identified Mr. Bowman as being involved in this is when he strolled into court last week. The only time. That's the only corroboration we have. No other independent witness, no one other than those 2 have placed Mr. Bowman there. And again, what the state has posited for his involvement with him essentially being one of a gang of 5, that's, there were also other witnesses that talked about being down there at the edge of this, at the edge of the Arch Center, where there may have been as few as 2 people, and the 2 people being Mr. Kane and Mr. Melendez, the people that pled out and admitted to what they did. So, Judge, again, just based on that and the previous argument made, we don't feel that the state has met their burden, low as it is, even under this standard, and the case should be dismissed as it is against Mr. Bowman.
The court does not take lightly its role in reviewing Rule 20 motions. As a preliminary matter, I'm just going to state that I am denying Marcus Morris and Gerald Bowman's Rule 20 motion. Just to cut to the chase, I'm also denying Markeith Morris's Rule 20 motion, but I'm going to explain in more specificity my explanation, and I will also give the option of having me explain with more detail why I am doing that. But to the extent that I choose to make a record, or you request that I make a record regarding the potential inferences that can be made, I am sensitive to the court laying out a theory of the case for the state. And I do not want to take that position on that I am going to synthesize the facts and lay out a position for the state, which may be an inference that results in the jury reaching a particular verdict. If defense requests, if Markeith Morris's counsel specifically requests that I make that record, I will make that record, but I will not make that record unless specifically requested. The Rule 20 motion, as indicated, is to be granted when there is no substantial evidence to warrant a conviction. And the substantial evidence is to determine if proof that reasonable persons could accept as adequate and sufficient to support a conclusion of the defendant's guilt beyond a reasonable doubt. And the court is to consider both direct and circumstantial evidence in determining whether substantial evidence supports a conviction. Further, when reasonable minds may differ on inferences drawn from the facts, the court must submit the case to the jury, and the trial judge has no discretion to enter a Rule 20 motion. In this instance, as I will discuss as a principle, I will not lay out any detail regarding the accomplice lookout theory. As a principle, I understand that Ms. Sherrod testified that one of the Morris brothers was kicking and punching Mr. Hood after the initial assault and before the assault at the end of the road at the intersection of Coulter, and that the second twin was punching. I realize the significant cross-examination of Ms. Sherrod, and I realize that judicial officers often have to make difficult decisions when entering a Rule 20, but when it comes down to credibility, and a reasonable juror could accept Ms. Sherrod's summary and testimony as true, the court must submit and will submit this issue to the jury. In this instance, the court is leaving the credibility to the jury and is denying the Rule 20 motion both on the theory of principal and on accomplice as the lookout. Mr. Ballinger, would you like me to state with more specificity the reasons that the court deems there are sufficient facts for inference for the jury to be left with this decision on Markeith Morris?
I would prefer that not be done, Your Honor, at this point in front of the prosecution. However, and I don't even know if this is an appropriate request, in the event that there's an appeal of this matter, I would like that your decision entered of record after the fact.
I will do so. Everyone ready for the jury?
Yes.
Your Honor, I just need to run my notes. I think I left them. Oh, there they are. Never mind.
Who's going first?
Oh, Your Honor, you know what? We should probably approach, or we don't have to approach, but I don't know if we should bring the jury in right now.
Right.
Because we have some complicated issues, and I think they're going to have to make some decisions. I would.
Can you approach?
Yes.
Everybody else can sit down. Could you bring the jury in? Yes, Judge. Please be seated. We are back on the record in the presence of the jury. Mr. Fisher, all defense counsel, and all defendants are present. Mr. Fisher, any additional witnesses from the state?
No, Judge, the state would rest at this time.
All right, ladies and gentlemen, I told you that we were going to take a break for 20 minutes. We broke for 1 hour and 4. And I am sorry again, ladies and gentlemen, if there's a delay, you have to hold that as the responsibility of the court in order to maintain the fairness of the trial. As I told you in the preliminary instructions, from time to time there will be breaks, and that is because I need to decide how certain issues will or may be presented to the jury in order to avoid any error. Given the late hour, what we're going to do is recess. I apologize for keeping you waiting for 1 hour just to send you home now, but I didn't know that that's what I was going to do until now. So ladies and gentlemen, we are going to recess for the evening. The admonition will continue to apply. I'll see you back here tomorrow at 10:30. All rise. Please be seated.
You've never seen me until you walk in this courtroom. Guys, what about the call number?
So at this stage, has defense decided what you intend to do, or are you still contemplating what you intend to do?
I am still intending,
Or do you need my rulings in order to decide what to do? I mean, you got
that's
my preliminary thoughts on,
right. Judge, I actually would be waiting and relying on whatever rulings you were going to make regarding limitations for Mr. Bowman's alibi defense before I made a final decision. But my inclination right now would be to rest on behalf of Markeith Morris and to you know, and to then, to the extent that you were going to allow the state to get into a broader examination of any witnesses that might be called, then I would like or believe to be lawful under the circumstances, make a record. And I don't have, other than what I've told you at the bench earlier, which is just regarding the relevance and your ability under Rule 612 and similar evidentiary rules to control the order and mode of testimony. I do think there are due process concerns regarding a defendant who has a presumption of innocence and does not have to offer any testimony on their behalf. And the state has rested to allow evidence to come in that would then require a defendant to take additional affirmative steps to defend themselves. So I realize it's not a simple solution, and I don't have a case for you at the moment, but that's my dilemma.
So, I'm not hearing a request for a motion for severance. I'm not hearing a basis articulated for a motion for severance. I understand your position. The preliminary comments that I made at the bench involve placing limitations on the state if one defendant intends to call individuals who were present at the scene to limit the state's cross-examination as to what that individual or those individuals may or may not have seen is preventing a thorough and complete cross-examination to inquire as to the credibility of those witnesses called by one defendant. I'm not making any rulings because I would ask that if you have any case support for your position that you submitted, but that's my sort of initial analysis is if somebody is called to testify and that individual was present at the scene.
Your Honor, and ordinarily I might even agree with you under these circumstances, but we're talking about an alibi defense, which is an affirmatively noticed defense that the defendant in question has to prove. And so the relevance of anything beyond the scope of that alibi defense is immaterial to the other defendants who are not relying on that defense. We already have all the evidence we're going to need regarding non-presence and mere presence. And so I understand, believe me, I understand the court's dilemma. And I don't have the case that says you must do it this way yet. And I don't even know if I'll find it by tomorrow morning. But I do believe that under the circumstances here, this is an affirmative defense that Mr. Bowman would have to prove because he's noticed it.
Well, and I guess my issue is to the extent that Mr. Bowman chooses to call a witness in order to proceed who was present at the scene. Mm-hmm. I know you've noticed 3 other witnesses, the barber and the 2 other people that were purportedly with Mr. Bowman at this, according to your opening, at the time of the event. If one defendant is intending to call individuals that were at the scene to say, at no time during this entire incident did you see my client, the state would have an opportunity to conduct a thorough cross-examination if this witness says, at no time during this incident did you see Mr. Bowman. In order to cross that, they would be able to question, well, what did you see?
Right.
Where were you? And what was going on when you were there? And what was going on in front of you and to your side? And who was present in order to test the credibility of that witness? And I understand the dilemma of the 3 individuals when one decides to call someone that the other 2.
Well, so let me put it in high relief for you, Your Honor, okay? So Gerald Bowman has whatever relationship he has with the Markeeff brothers, it's qualitative. I keep saying Markeeff brothers, I'm sorry, the Morris brothers. I believe in some respects that, I believe probably that the state could cross-examine regarding what happened that night. Did you see X? Was this person there? Did you see Miss Sherrod? Whatever. But there's a lot of familial history that Mr. Bowman has no concept of whatsoever, and that some of these, and that would have no relevance to an alibi defense.
So are you,
I'm also looking for the rule of severance, Your Honor, of whether I could even make that motion now. I don't even know.
but a motion for severance can be made at any time that it deems to be, but I'm not sure that there's a basis for it, but you can articulate.
I wasn't. And the other thing about statements that were made in opening, we all heard for the first time that Alonzo Hickerson had solicited perjury. Had we known that, that might have impacted the way we opened. So, and openings are not evidence, they are what they are, right? And we find out literally, and through the graces of some professional lawyering from the county attorney's office, we find out that Mr. Halal was going to tell us, we found out after we opened, and then we found out that from Mr. Miller. So it's a little bit, and I don't know, it's not disingenuous, but it's not necessarily fair that we would be bound to openings when a critical fact such as that wasn't even known to us at that point. So, you know, I don't know that I would hang my hat on the opening statements.
13.4 is what you're looking for, but
Indictment and information. There we go. So, you know, I don't have a good answer for you, Judge, other than I think that.
But let me understand are you asking that I limit cross-examination to only issues that you didn't see Mr. Bowman and only his physical presence at the scene, and if I don't restrict it in that way, that I only restrict it to that night and whether Mr. Bowman was present that night, and that the state cannot inquire of Julius Kane regarding anything that may or may not have happened. For example, this, well, okay,
That's
you
exactly
tell me.
what I'm saying. I'm saying.
I'm sorry, did you say that is what you're saying or that's not?
I believe that is what I'm saying. And again, I'm going to look at this more tonight, but I think that's exactly what I'm saying. There's an alibi defense. There's going to be testimony germane to the alibi defense. There's not going to be testimony germane to, well, do you have a relationship with Markeith Morris? Did you have a relationship with Marcus Morris? Did you go to Kansas with those guys? Did you live with their mother?
Sorry to interrupt you, but there was a lot of questioning of Mr. Hood and statements made in opening which are not evidence about this $300 debt. And then there were questions of Mr. Hood about him being alone with Mr. Kane, spending time alone with Mr. Kane, what I assumed was setting up, in part, what was stated to the jury about a motive for Julius Kane to want to harm Mr. Hood, separate and distinct from any falling out that purportedly happened between Marcus and Markeith Morris and Mr. Hood.
Mr. Hood also testified before we found out that, I believe, and I might be wrong about this, Dan, if I'm wrong, correct me. Mr. Hood also testified before we found out that two witnesses were going to come in here and testify that Mr. Hickerson had solicited them to lie. So, you know, again, things happen during a trial and people have to change courses in some respects.
I realize that, but it's not, or I'm not hearing you say it's the fault of the state for not knowing this information. So to the extent that there were questions asked by defense that now has put evidence in front of the jury, and now if one defendant calls Mr. Kane to the stand, and there have been a lot of questions throughout the course of this trial as to motive or lack of motive or independent motive, if you're asking me to prevent the state from questioning that witness who's now called by one defendant.
Who has a completely different defense from the other defendants.
And I would say, to the extent someone suffers from that, it would be Marcus Morris and Markeith Morris. The only evidence right now are Mr. Hood's descriptions on his direct and cross of those issues. I mean, if there's no other evidence that comes in, that is all the jury has. If the jury doesn't get additional information about items we discussed in our opening statements, then again, we're the ones who take the risk and the ones who suffer from that. But that, the court has to balance the state's ability to present, a sort of full and complete case that in part enables it to cross-examine witnesses to establish their credibility or lack thereof. And so that's on one side, and on the other side are the due process rights of Marcus and Markieff Morris, who have every right, the state having rested, to have this case go to closing arguments and submit it to the jury without any additional evidence coming in now.
So, what I ask of you is, Mr. Lackey, you decide what you intend to do and notify your colleagues, and then to the extent that you are requesting that I restrict the state's cross-examination, I would like you to put in writing what you want that restriction to be. And I anticipate it will be perhaps a layered. You may say, Judge, I don't want you to let the state cross about anything other than that Mr. Bowman wasn't present. And if not that, given sort of my initial thoughts to you, then we want this limitation. And if you have a further position, and then if you have any other requests of the court in order to solve what you perceive to be the procedural or the due process challenges faced by this dilemma, you will let me know what other alternatives you would like me to consider. But as of now, you are joined. You do not have antagonistic defenses.
Understood.
Thank you.
Thank you.
Thank you, Judge.
Can I see you guys back here, though? The jury's coming at 10:30. What does my calendar look like tomorrow?
Did you bring this one?